seconds. All right, it's 2:22, so. Yeah.
Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Yea, all persons having business with the Appellate Division, draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon. I'm about to call the calendar. Please listen for your name. I will also indicate the time that's been allotted for your argument. The first case is People v. Sylvester. The appellant gets 5 and 1, the respondent 4. Kivo versus Burke. The appellant gets 5, the respondent gets 2. M. Children, that's a submit. 90th Street Corp. versus 203 West 90th. The appellant gets 7 and 2, the respondent 7. People versus Mirabel. The appellant gets 5, the respondent 4. Lance and Loader versus American Tack. The appellant has 5, the respondent has 5. People v. Michael Hall is submitted. Montera versus KMR Amsterdam. The appellant has 5 and 2, the respondent 5. Weisenfeld versus Iskander is submitted. Francis L. versus Lewis O. is submitted. People versus Morris. The appellant has 5 and 1, the respondent 5. People versus Tripathi. The appellant has 8 and 2, the respondent has 8. Kosovisky versus Kosovisky. The appellant has 7 and 2, the respondent has 7. People versus Sherman Gamble. The appellant has 4 and 2, the respondent has 4. Verges versus Concourse Residential. The appellant has 5, the respondent is submitted. People versus Anonymous. The appellant has 9 and 2, the respondent has 7. Strite v. Bombard is submitted. Napoli versus Byrne is submitted, and Napoli versus James is submitted. First case, People versus Stephen Sylvester. All right, the appellant, you may proceed.
Good afternoon, Your Honors, and may it please the Court. Attorney Megan Byrne for Appellant Stephen Sylvester. Mr. Sylvester should be adjudicated a first felony offender because neither of the predicates that the Court found are actual New York equivalents. As Your Honors know, this is a statute-by-statute comparison. It's one of the rare areas of the law that's very strictly technical.
Counselor, before you go there, with respect to the Hobbs Act, haven't we already ruled in People v. Robles on that issue? So why are we revisiting it?
So in Robles, there was a narrow question about the Hobbs Act, which was whether the Hobbs Act, or whether New York larceny by extortion covered future threats to property, because there the narrow argument was the Hobbs Act and the New York equivalent were not equivalent to the New York statute because the New York robbery statute didn't encompass future threats to property. Here, we are not asking the courts to reconsider that question. Instead, we've raised 3 separate issues about the Hobbs Act that this court has never looked at, including whether it's a general intent crime, the Hobbs Act, as many circuits have found, as cited in our briefs, versus the specific intent required under New York statutes, whether actual force to property is a New York felony, and whether the Hobbs Act requires a substantial deprivation of property, as New York does. So we're asking the court to look at 3 completely different issues.
You concede, don't you, that The two predicate felonies upon which the sentencing court relied, one was the North Carolina conviction, the other one was the Hobbs Act conviction. Either one of them could independently serve as the predicate for enhanced sentencing here. Is that correct?
Yes, if this were a court were to find one but not the other, that would be enough for the predicate
Right.
as it is.
Okay, so your burden here is to convince us that neither one fits the strict equivalency.
Exactly, yes. We have to knock down both of them in order for this to make a change in his predicate status. So I briefly touched on the Hobbs Act and the three reasons that we don't believe that that is a predicate. As to the North Carolina conviction for breaking or entering, one easy thing to kind of focus on here is the definition of building and how it is different in New York and from North Carolina. In New York, it's any structure used for overnight lodging of people or used by people for carrying on business. So either people are in it or they're using it to do business somehow. For North Carolina, it's any structure designed to secure within it any activity or property. Just by its very terms, you can tell this is a very broad phrase, any activity or property.
But how is it different?
So it's different in that there could be property stored within a structure that is obviously not a person and also not used for business. That would be a building under North Carolina law. For instance, I mentioned a case in which there was a boxcar. It was like an old boxcar, had beer stored in it, not for the selling of beer, just some beer stored in it. The defendant went inside, stole the beer, and the court held that was not burglary under New York because the boxcar was not used to lodge people or to carry on business. Under the North Carolina definition of securing any activity or any property, that would be a building, and that would violate the New York law, or the North Carolina law. And as your honors know, the New York law has to be the same or broader. It can't be that the North Carolina law is broader, which is the case here. And then if I could just quickly turn to the sentence reduction point for Mr. Sylvester. Here, Mr. Sylvester, the minimum was 1.5 years. He was sentenced to 3 years. His case is a case punctuated by a substance abuse where we can kind of pinpoint the cause of it. When he was just 17, he was incarcerated in a federal prison. And because he was in the federal system, he was kind of taken across the country, away from his family. At this young age, as a teenager, he was put in solitary confinement for 19 months in the federal system, which is, as your honors know, something that New York doesn't even allow. And after he came out of that experience, he became addicted to heroin while he was in that federal system. So when he got out years later, that drug addiction led to the instant conviction for the instant narcotic conviction that he has. So it's important to note that, this is a kid in his mid-20s who's had severe trauma in his life, but who needs a sentence or demands a sentence closer to the minimum of 1.5 years.
Thank you. Counselor?
Thank you. May it please the court, Philip Tisney for the Manhattan DA's office. The first thing I'll say is that this defendant was released about a week ago. I'm not even sure that he wants to go back on a new predicate adjudication and resentencing. I haven't heard anything from his counsel about that. On the substantive point on the predicates, as Your Honor pointed out, we only need one predicate, valid predicate here to sustain the court's ruling below.
So
We have
what's
three,
your
we think.
strongest? Which one's your strongest argument?
Well, both of the North Carolina convictions we think are rock solid. The breaking or entering statute, as we've set out in the brief in a fair amount of detail, is identical to...
What about your adversary's point that how we define building is different?
It's not different, Your Honor, and we know that because the specific language that they claim broadens North Carolina law has been construed by the courts there not to broaden the term building. The definition is confined to those things that meet the ordinary meaning of the term building. In New York, burglary encompasses breaking or entering into anything that's a building and other things. So in fact, in this point, New York's law is broader than North Carolina's law. This is not a situation where the two are materially out of step. The other points on the breaking or entering, we've set out in the brief. There is the conjunction between breaking or entering in North Carolina law, but attempted robbery or attempted burglary in New York covers that. And then the mens rea point has been construed by the North Carolina courts to align exactly with New York law. So the breaking or entering statute is probably our strongest. We think the attempted robbery is also strong. They point out to a distinction between robbery in New York and North Carolina, and I will grant them that is probably true with respect to the crime of robbery, but his conviction, of course, is for attempted robbery, and that distinction just doesn't exist in the context of attempted robbery. So those two felonies align as well. On the sentencing point, I'll only say that he's waived this. He waived excessiveness review with respect to a 4-year sentence, and then he got a 3-year sentence. I don't see any room for him to argue that that is excessive. And even on the merits, it's not, because this is somebody who has a fairly lengthy criminal history and absconded while his case was pending in this court. So the 3-year sentence that he received was fully fair. Unless there are other questions, Your Honors, thank you.
Thank you. Counselor, you have rebuttal time?
Briefly, Your Honor, we would note that the second North Carolina case is inapplicable and not proper for this court to look at, as it was never ruled upon as a predicate by the trial court. Regarding the breaking or entering, though, the thing about building, the distinction we're making isn't about the physical structure. It seems that the structures are very similar, but what's different here is about what goes on inside the structure. In New York, it has to be people are in it, sleep, lodging, or carrying business in it. So if there's only things in it, it has to be for business. In North Carolina, what can go on in that building is any activity or property, by its definition, very broad. Regarding the waiver, Mr. Sylvester was told, as part of this plea, you're waiving your right to appeal, and this is a separate waiver, but wasn't told what it means to be a separate waiver, wasn't told that it wasn't automatic. He was then also told, in general, you're giving up your right to appeal this matter.
But didn't the court distinguish the difference between right to appeal and trial rights?
In that he said them at different times, and he said the right to appeal is a separate right, but what has to accompany that, and what courts have said, is separate and distinct from the rights automatically waived. And it's from the rights automatically waived that's the important part, and that's the part that Mr. Sylvester didn't get here.
Thank you.
Thank you, Your Honor.
Thank you both. All right, the next case is Kivo versus Burke. Okay. All right, the appellant, you have 5 minutes. You can begin.
My name is Louis Kivo. I'm the plaintiff appellant in the case before the court. Referring to myself as Kivo, and the Louis F. Burke PC will be referred to as Burke. I'm seeking to reverse the Honorable Alan C. Marin's decision and order granting Burke the summary judgment motion for the following reason. And I will prove that Burke failed to use the ordinary skill and knowledge of an attorney, which is commonly possessed by an attorney, and in doing so was the proximate cause of me losing my $790,000 in damages.
Mr. Kivo,
Yes.
there's a expert opinion here, essentially saying that the defendant didn't depart from the standard of care while litigating the matter before FINRA. How do you respond to that?
Well, the expert was only shown what Burke showed him. In the reply brief, there's a list of 20 items which which the attorney included for me, showing that Burke hid discovery from me, as well as my own investigation of evidence to show that Burke deliberately did not show that information to his expert, David Robbins. So his opinion is only based on one-sided, only what Burke showed him. He hid material from him, the same material he hid from me, which I will expound on. And in doing so...
Couldn't you have hired an expert and showed him that material that you believe that the respondent's expert didn't have at hand?
This is basic perjury, fraud,
Listen
and
to me.
identity
You
theft.
have to answer my question, though. You had that material, correct?
Yes.
Couldn't you have shown it to an independently retained expert and obtained a different opinion?
I don't think, it's not mandatory to have an expert. In my case is common sense. In New York, common sense. Any fact finder, any juror with a GED diploma knows what perjury, fraud, identity theft, and forgery is. This is common sense. And if you let me...
You have
Well-
a minute and a half, so you can finish up your argument.
Burke committed fraud, perjury. Burke failed to discover fraud, perjury, and identity theft that any other attorney who has knowledge and skill would have done. In addition, Burke fired his financial expert in my case, Bruce Larimer, who pointed out that Oppenheimer was using my margin, which is an infraction, pledging it, and that pledging it for trading an aluminum corporation of China, which was not in my portfolio. Michael Lesser committed fraud, who was my broker, and Burke failed to cooperate with FINRA, who sent him a letter and multiple emails asking for his cooperation of the servicing of my account by my broker, Michael Lesser, and asking me to cooperate. Burke never gave me this information. Burke hid it from me, and this is proof positive and, that there was a pattern by Burke in committing these negligent acts. I can't make this up. It's all in my records and the briefs and all the
Right.
documents that the court has.
need-
This has been going on for
I need you to
8.5
wrap up,
years.
sir. You're out of time, so you can wrap up. Okay, thank you. Counselor, you have 2 minutes.
Thank you, Your Honor. What you pointed out was very prescient. What he had to do was, first of all, submit any of these documents that he says are in his favor into the record, and he did not do that, nor did he hire an expert to rebut our expert's opinion. Virtually everything that was just argued now is not in the record. This is not a fraud case. This is not a perjury case or identity theft. It's a legal malpractice case. And in this case, it was about Mr. Kivo claiming that he placed orders with Oppenheimer that weren't executed. To this day, the only evidence of that is his own testimony, which was provided to the panel, the FINRA panel. And they came to their decision. They awarded him $40,838 and didn't give him the full amount that he wanted, but that was their decision, weighing the evidence, seeing that there were no order tickets, no documentation other than Mr. Kivo's testimony to support that these trades were
In this
ever
case,
placed.
wasn't there also then further proceedings before SDNY and then the Second Circuit, essentially an attempt to vacate the award?
Yes, Mr. Kivo did attempt that, and it was rejected, both by the SDNY and the Second Circuit. Unless the judges have any further questions for me,
My colleagues have any further questions?
No questions.
Okay,
thank you, Your Honors.
Thank you. The next case is 90th Street Corp. versus 203 West 90th. Please step up. Okay, Appellant? You can proceed, sir.
May it please the court, Michael Cole, Cole Hanson Chester for appellant. In finding forfeiture of the tenant's $316,668 security deposit, the lower court ignores voluntary surrender of the premises, landlord's request demanded prior to the end of the agreed period of occupancy.
Here's my question to you. Why is the lower court incorrect in finding that the stipulation that settled the litigation for non-payment provided for the landlord to ask for a surrender when your client failed to otherwise remit in advance the use and occupancy due for May? What's wrong with that analysis?
Let me give it to you from the record then. This is the record of what happened with the rent. I call your attention first to record page 571. In that email, it's an email from the tenant's new tenant, the new prospective tenant, to me in April. And he says, I have a new deal with landlord. On that same page is my email to the new tenant's attorney, Weisberg, and I say, remember, you pay the May rent. Then, the May 6th email from the landlord's attorney. This was just before the closing. It was originally scheduled, I think, for the 7th, and it ended up being on the 12th. On the 6th, the attorney for the landlord, Olshever, says, and this is on R71, she says, remember, to the tenant's attorney, bring the check for the May rent. The closing happened the following week on May 12th. And as you know, no one's disputing this, the new tenant came in and he had a new deal, and the closing aborted. Nothing was said. The next day, in the morning, I received an email from John Ramson, and he said, we want possession back. Now, you'll see that the plaintiff, Boletto, he indicates that he made it his business, and this is in the deposition, to return the keys to the landlord the next day. Let me tell you where that appears.
Under the terms of the stip, when was May rent due, or May use and occupancy due?
I'm sorry,
Under the terms of the stipulation, when was May UNO due?
May UNO would have been due on May 1st if there was not another deal between the parties.
Is that what the stipulation says, or is that a term you're adding to the
I
stipulation?
don't think the stipulation deals specifically, but generally speaking, May 1, May 5, that's when this stuff was.
So you were in default essentially on May 2nd, correct?
Say that?
You were in default on May 2nd.
We were not in default on May 2nd because the landlord had agreed that the new tenant would pay the rent, and that is memorialized in the email from the landlord's attorney on May 6th. Let me give you that site. This is the Olshever email. Bear with me. This is the email from the landlord's attorney on R71.
And the email went from the landlord's attorney to who?
To the tenant, new tenant's attorney.
The new tenant. So
Harold
by that,
Watson.
were you or your client copied on that email?
Yes.
You were. Did you have anything in writing about the assignment or the consent to the assignment?
What happened was they did not reach any signed documents. The idea was to do it at the closing, and we all appeared with the expectation it would be done.
That should have a contract and closing at the same time?
There was papers, contracts prepared for the assignment of the lease and the new rent. And as the landlord's attorney had said in the email, it was expected that the May rent would be paid by this new tenant. That was our deal. Everyone was on board with that.
And when was the closing supposed to take place?
The original closing was supposed to be May 7th, so that email from Olshever was a day before.
So what happened on May 7th?
They just didn't want to go on the 7th. I can't remember who didn't want to go, but somebody didn't, so we had to move it a week to May 12th.
Okay.
Now, in terms of the damages, I'd like to point out to you something very clear from the record. John Ramson, who is the House counsel, and he was the attorney of record, he says in his deposition testimony at R 374 through 375, when I asked him, well, what damages did you see on the premises? And he said, well, I didn't see anything. I don't recall any. However, he says to me, I looked at the pictures that the tenant produced in discovery, and I saw damages there. Now think about that for a second. That means in 2018, when he saw the pictures, which is during discovery, or 1718, he first realized there were damages. Therefore, the letter he wrote in 2016 saying we're not returning we're not returning the security to you, there were no damages he knew of. And Ruiz, if you'll pardon me with the mask, I apologize. Ruiz, I had never
You don't
met
have to
him.
apologize. We're happy you're wearing one.
Ruiz, who I had never met before, comes to deposition, and he was the landlord's witness. And I said to him, Mr. Ruiz, what is your qualification to give testimony for the landlord? And he said on page, I believe, 279, I am here because I inspected the premises. I looked at it, and I said, ask him the $64,000 question, well, what'd you see? He said it was completely clean. That's not a extrapolated answer or something I pulled out. That's what he said. He was not rehabbed by his own lawyer to say, oh, yeah, well. And then, and here's the interesting thing.
I'm going to ask you to wrap up this point.
I'm going to wrap
because
it
you're
up
out of
right
time.
now.
Okay, thank
In
you.
the affidavit in the cross motion, a year later, he then says, I saw all this damage, and I saw this, and I saw that, and I saw the other thing. Completely diametrically opposed to his deposition testimony.
Thank you.
very much.
Thank you. You can proceed.
Good afternoon. If it pleases the court, my name is Greg Zucker on behalf of Respondent 203 West 90th Street Retail LLC. This is real simple. In January 2015, two sophisticated parties, represented by counsel, entered into a stipulation. It's a binding contract.
Counselor, the best argument I think the tenant has is that the terms of the stipulation were modified, and as a result of that, in essence, a new agreement was put in place with respect to the surrender, the attempt to have somebody else come in, et cetera, et cetera. How do you respond to that argument?
Sure. First of all, that argument's not ripe for appeal because it's raised for the first time in the appellate brief. The argument below was that there was going to be an assignment, and if and when that assignment occurred, that new tenant would be responsible for rent if landlord agreed to it, which is consistent with the lease. As to your question, Your Honor, this is real clear. Everything we did was consistent with the STIP. If they failed to pay the May rent, if they failed to pay the May U&O, use and occupancy, in advance, the $60,000, we had an express remedy under paragraph 3, which was to execute on the warrant of eviction. We did that. They failed to pay May, they failed to pay June.
But I think their argument is that the reason they didn't pay May is because there were negotiations with respect to a new tenant coming in, and obviously they didn't want to pay, and then you were going to get it from, get double payment from the new tenant.
The only time you ever get to the point where the Rose v. Spa Realty case, which is where you have an oral modification to a written agreement, is when there is action that's unequivocally referable to this new deal. Every action the landlord took was unequivocally referable to the stipulation. If they didn't pay the use and occupancy, we exercised on the warrant of eviction. Since they didn't leave the premises in broom clean condition and didn't pay the U&O, we complied with paragraph 6, which is you only get the security deposit back if and only if you comply with the STIP and you comply with the lease as it relates to the security deposit. Here, that didn't happen. Counsel raises what was the evidence below that didn't happen. There's testimony from his client, Mr. Boleto. It's on the record. It's at R716. He takes photographs, a series of photographs, and is asked the question, what is JB Exhibit 13? These are pictures that I took of the store once everything was removed. And it's outrageous what they did. They removed toilets.
Can we get
and
away
sinks.
from the repairs for just a minute? Because it's your position, as I understand it, that leaving aside the repairs, that the default in the payment of U&O otherwise entitled you to retain the security deposit in any event. Is that your position?
That is correct.
So what is there in the record about this May 7th purported contract and closing that you were supposed to participate in connection with this?
If you look at paragraph 4 of the stipulation, which is consistent with that, although the landlord had no obligation, if they were able to find another supermarket to come in, and that supermarket was going to agree to pay the rent and the additional rent, in that instance, the landlord could have agreed to allow that assignee to occur. That never occurred. There was no modification to the agreement.
So again, with respect to May rent, is it still your position, based on what my colleague is saying, that the default occurred on May 2nd, or would it be after the deal fell through?
No, the default occurs before May 1st because it says the U&O has to be paid in advance. So there's a default there because they failed to pay May. And by the way, unlike the cases they cite, like the White's case, where there was a situation where a payment was due on March 16th and it was received on March 18th, and then the person paid the other two obligations, and then there was an execution on a confession of judgment. Here, they never paid anything.
Well,
they never paid May.
they didn't pay because their position was that there was a surrender, and therefore June rent wasn't due as well as May rent, correct?
But what occurred is exactly consistent with paragraph 3. It says that they're supposed to pay this money in advance, and if respondent defaults and does not make one or more of the $60,000 monthly payments and the payment of additional rent, then the warrant may be executed after service of marshal's notice of eviction. All we did is comply with the stipulation, a binding agreement that was signed by counsel in a landlord-tenant proceeding. And let me just make a couple other points. As I want to say 4 things, really. The stipulation is a valid and binding contract. You got 2 sophisticated parties here. There was not unequal bargaining strength. 2.
Let me ask you
Yeah.
another question. So, and can we tell from this record, by May, you had another tenant in the premises. Who identified that tenant? Who brought that tenant to the table?
Oh, when a year after the security deposit, that timing when it was supposed to release, we still didn't have a tenant at that point.
You did not?
We did not.
So
And
you never had, there was never an assignment that occurred?
Correct, no assignment.
Never an assigned tenant that was identified?
Correct.
And is there any evidence in the record that you believe exists that on May 7th you were supposed to attend a contract and closing?
The idea was going to be that if and when a tenant assignee was going to pay us money in accordance with what we requested, then we would have agreed to a settlement at that point, but it never occurred. It was aborted. They never agreed to pay any money.
Was somebody identified as the proposed assignee?
I don't know who the name of the tenant assignee was,
But
but I
it
know
wasn't the person who ultimately came in as
No,
your
no,
tenant?
no, no. What occurred was a year after the fact, They requested their security deposit. And we wrote back in a letter that was unequivocal by Mr. Ramson that said, you're not entitled to it. Look at the stipulation. You didn't pay your UNO as you were required to in advance, and you didn't leave the premises in the condition required. But at that point, Judge, there was no tenant.
Okay.
And just one other point, they raise here the issue that, equity abhors forfeiture. That's not this case. There's not a situation where you have a tenant that put millions of dollars into a location and was one day late on an option. This is a situation where they're seeking money damages pursuant to a stipulation. Ironically, they're seeking money damages pursuant to a stipulation, but they're seeking to be excused from the terms of the stipulation, i.e. paying UNO on time and leaving in a broom clean condition. This is a situation where two sophisticated parties agreed to what the deal would, and everything the landlord did was completely consistent with that. And as far as the premises, counsel saying that what the records say, I respectfully disagree. Mr. Boletto, who's
I'm going to ask you to just wrap up. You're out of time.
Mr. Boletto, who is his client, testified and took the actual pictures that showed the toilet was ripped out, the sink was ripped out, the hole in the floor. This is exactly like the case that we cited too, which involved a butcher shop, and there was wiring and holes and what have you. Thank you, Your Honor.
We understand your argument. Thank you. Rebuttal?
By the way, it's a pleasure to be back in court, judges. Thank you.
It's interesting, right? Yeah.
Let's talk about the photos. Counsel has mischaracterized these photos and the
But,
test.
just how you put it, characterization. So you're asking us essentially to weigh what the evidence is. Isn't that really the function of the trial court as opposed to us?
What are we weighing?
You're asking us to weigh the evidence with what the photos show. Isn't that the obligation of the trial court as opposed to us?
Well, we didn't come from trial. We came from summary judgment. So if you were to say to weigh it by the trial court, well, I guess that's true because we were supposed to go to trial and we didn't. This is on summary judgment. So to the extent that you raise evidence, sure, absolutely we should,
But
trial court should weigh it. But let
Yeah,
me-
but the court granted summary judgment on the default in UNO. On the counterclaim for the repairs, the trial court said there were issues of fact. Why isn't that right? They actually, the trial court said there were disputed issues about the repairs insofar as the counterclaim was concerned. Insofar as the claim in chief for the for the security deposit, the court based it on the default in payment of UNO, which would have been a separate independent basis under the stipulation. Isn't that the analysis?
Let me point out the error here. There's no trial here. This is summary judgment.
I understand.
We didn't get to
Believe me,
trial.
I know what summary judgment is.
But here's the thing, on the UNO, first of all, we have to understand there was a surrender of the premises. Now, UNO, if you want to talk about UNO,
But Counselor, I hate to interrupt, but your adversary says UNO was due May 1st.
it was not. As I said to you, as you can see from the agreement of the parties in the record, the landlord's attorney confirms the deal that the monies for the May rent was due at the closing, not on May 1st. That's an admission in the record, and again, I'll give it to you.
No, we have it, sir,
Okay?
and you're out of
So
time.
that's the landlord's lawyer. There is an agreement here by all the parties to modify that stipulation.
And that's the issue, and I think we understand your argument.
Let me just point out for the photos, what the,
I actually believe you're out of time, sir, so finish your thought, and we're done.
the thought I'm finishing is that the witness said this is prior to the completion of cleanup, not after it was completed. And he testifies that he had done the work to complete it afterward with the landlord cooperatively. And that appears
That's, we have the record, we can find it.
374 to 375.
Thank you. Thank you. Okay, the next case up is People versus Mirabel. Okay. You may proceed.
Thank you, Your Honor. May it please the Court. Nicole Giuglas for the appellant, Mr. Eddie Mirabel. Your Honors, this case is a prime example of one in which a strict application of the RAI results in an overassessment of an individual's risk. Mr. Mirabel, when he was 20 years old, engaged in sexual intercourse with a 14-year-old young lady who, by all accounts, was a willing participant and, but for her age, consented to the encounter. Given the circumstances present in this case, a Level 2 assessment exaggerates Mr. Mirabel's risk, and a Level 1 assessment is more appropriate. Both the board and courts, including this court, recognize that a downward departure is often appropriate in statutory offense cases like this.
It's a fact-driven inquiry, though, isn't it? In other words, the assessment, the points given for the factors are appropriate, and the issue is whether you should deviate from it in the case of a particular statutory rape, because sometimes it overassesses the risk of the defendant. Isn't that the way we look at it?
Yes, that is correct, Your Honor.
Right. So if that's true, in determining whether this is a case where we should deviate, shouldn't we look at the individual circumstances of the commission of this particular crime?
Yes, Your Honor.
Okay, so what about this crime would make factors 1 and 2, would create the giving of points for factors 1 and 2 an overassessment? Why?
So taking factor 2 first, in similar cases, courts look at whether the registrant has a history of sexual offense, whether the individual and the complainant had some sort of dating or prior relationship, and the age disparity between the parties.
Well, let's focus on the age disparity. Are there any cases that have a black letter law or rule about what age disparity would result in an overassessment and what won't?
There is no black letter law, but there are cases where individuals have been granted downward departures where there's been a greater age disparity than there is in this case. So in Soto, for example, People versus Soto, this court remanded to the lower court for consideration of a downward departure, a case where the complainant was 14 years old and the registrant was 23 years old. And in that case, after it was remanded, the downward departure was granted. In Fisher, People versus Fisher, the second department ordered a downward departure where the registrant was 19 and the complainant 13. In Marsh, the second department granted a downward departure where the complainant was 15 and the registrant was 26 years old.
Now, in these cases, are they comparable with respect to the physical injury that the victims sustained in this case?
There's no information in the cases whether points under factor 1 were scored in those cases, but I would note that in this
But you would agree here, wouldn't you, that the injuries were, to this 14-year-old girl, rather traumatic?
Yes, and that is why factor 1 points were appropriately scored. However, the board's purpose behind factor 1 is designed for individuals who perpetrate sex offenses with intentional violence. In this case, there was no use of force, no indication of any intent to cause physical injury or to cause any injury. The injury, all parties agreed, was caused by the act of intercourse itself. In both factor 1 and factor 2 points being assessed, they overassess Mr. Mirabel's risk. He has no history of sexual offending. His RAI score, even with the points under factors 1 and 2, is on the low end of the range for a level 1. And these are all considerations that other courts, including this court, has taken into account when granting downward departures in statutory offense cases. Given the circumstances in this case, as stated, Mr. Mirabel is most appropriately scored as a level 1 registrant, and we ask that this court exercise its independent discretion in granting a downward departure.
Thank you, Counselor. You may proceed.
May it please the court, Catherine Kulkarni for the people. Your Honors, in none of the cases my adversary cites is there any indication that the victim suffered the kind of severe physical injury that the victim suffered here. I'll just briefly remind the court that this victim suffered a tear to her vagina. And
You really don't have to remind us. We're really familiar with the record.
Sure. Well, given that this was a pretty severe injury, this is not a statutory...
But how do you respond to your adversary's argument that there wasn't really an intent to cause this injury, it was a function of intercourse?
Well, I believe my adversary is making a distinction between injury that's caused through the act of sexual intercourse itself versus independent injury, such as some type of forcible compulsion. And there really is no distinction under Factor 1. The SORA commentary and guidelines refer to the penal law definition of physical injury, which is impairment of physical condition or substantial pain, and that's exactly what she suffered here. And even if there was no independent force, there obviously was some force used during sexual intercourse itself to cause her to sustain the type of injury she sustained. So as the SORA court found below, at the very least, just a complete callous disregard for the well-being of this petite 14-year-old girl. The age difference is significant. 6 years is a long period of time.
But your adversary points out that there are cases where the age difference has been greater and cases that have been remanded under those circumstances. So that in itself is just one factor, right?
It's one factor, Your Honor, but I think when you put that together with the physical injury, the fact that there was no sort of long-standing romantic relationship between these two, they did meet this summer, and they started texting. They met at a pool party, they started texting, and then they agreed to have sexual intercourse at the defendant's friend's apartment. So, this wasn't an act born out of a long-standing romantic.
There is authority, though, that the the points given under factors 1 and 2 may result in an overassessment where it's a statutory rape, which is what occurred here, correct?
That's true, Your Honor.
All right, but in our reviewing it, and you have to look to the facts of a particular case, it's an abuse of discretion standard in looking at what the trial court did on this.
That's right, Your Honor,
You're
yes.
shaking your head, yes, and we'll
Sorry.
note it for the record. Okay. And here, even if there are cases where the age disparities are similar in which the court found an overassessment, doesn't mean that there was an abuse of discretion in this particular case.
Absolutely, Your Honor. It is such a fact-intensive inquiry, and the simple fact that this age difference has been ruled to not prevent a downward departure in other cases, really, it should not be given a lot of weight here, given all the other factors, the physical injury, the fact that they had met not that long ago, and that in combination with the 6-year age difference all made this a case where both the board and the SORA court thought that a level 2 adjudication was the appropriate reflection of his risk level, and the people asked that the court keep that intact. Thank you very much.
Thank you. Okay, you have no rebuttal. Okay, thank you both. Okay, the next case is Lancer and Loader versus American Tack. You may proceed, Counselor.
Thank you. Good afternoon. May it please the court, Daniel Milucci, local counsel for Rogan Jones, attorneys for the defendant American Tack, who I'll refer to as Amertac. This is a case arising out of a purchase of the plaintiff's LED lighting business. The purchase consisted of various portions, the main ones being an asset purchase agreement, which is referred to throughout as the APA, and there was also an independent contractor agreement referred to as the ICA.
Counsel, there were two separate agreements, correct?
There were two agreements, but they were all part of the overall transaction, correct?
Were they integrated into each other?
Yes, they are.
How so?
It's set forth in the agreement itself that they are integrated. There are several, in several locations, there, including there's a wherefore section, which is cited in the papers. But they were certainly integrated, and in any event, the point.
I think, isn't the response that the AIA explicitly incorporates exhibits, which one of the exhibits was the ICA. I think that's how you get to the incorporation argument?
That's correct as well.
Okay, so let's assume there's incorporation, and also let's assume that Levine breached the ICA. Why, under these circumstances, is that a set-off against the sums owed, the defendant owes to plaintiff, which is a separate company?
Because it is essentially a failure of consideration. As was acknowledged even by the trial court, the ICA was...
There are no cross-default provisions in the ICA and the APA, correct?
There are set-off provisions.
No. With respect to Levine, if Levine breaches the ICA, that is a breach of the APA. There's no cross-default provision in that respect, correct?
There's no clause that states
Okay.
that specifically.
So what's the provision that allows you to say that Levine breached, we're litigating that issue in Jersey, but we're entitled to a set-off under what provision of the APA?
Article 10 is of the
indemnification
APA
provision.
speaks to set-offs, the entire section. Where there is a failure of consideration, as here, and in that regard, that's the failure of Levine to follow through on his responsibilities.
How
with
is
the
that a
ICA.
failure of consideration? Isn't that just a straight breach? Because if there's a failure of consideration, then presumably, I guess the contract is then extinguished. But in this case, there's just a breach, right? Levine didn't perform, you say, but how is that a failure of consideration?
Well, he's a key man. He's an insider. He's supposed to be there to nurse that business forward.
Who signed the independent contractor agreement?
Levine.
Did Lancer sign it?
I don't believe Lancer separately signed that.
Doesn't the
portion.
indemnification provision state that they're only to indemnify if they are party to the agreement?
Right, but part of what they agreed to deliver was Levine. He was an insider. He was the CEO of their company.
But the indemnification provision also provides specifically that the indemnification concerns any breaches by plaintiff, i.e. the corporate plaintiff. It doesn't say anything about Levine, right?
It doesn't speak to Levine
So then how
specifically,
can, how does that provision give you a basis to say, in effect, that's a cross default provision?
because that's an integral part. That's a necessary part of being able to take over the lighting business. That was contemplated by the parties. It was a condition to even close the deal.
Now, in other situations, weren't there some cross-default provisions included in the agreement?
I'm sorry, Your Honor?
Were there other cross-default provisions in this agreement?
And some of the other agreements that were attached as exhibits to the main agreement.
Right, there were, it was all part of the overall agreement.
But you had cross-default provisions in those, as opposed to in the ICA, there were none.
So the point being is that the parties understood when they wanted to create a cross-default provision, they could, and in certain instances, like in the indemnification provision, there is no explicit cross-default. Correct? Isn't that something we should look at to see whether or not your argument has merit?
I suppose that would be a factor, but for the court to assert as a matter of law that the defendant cannot assert any defenses or counterclaims on that basis, I mean, that's something that the plaintiff would have had to proven as a matter of law.
Looking at the contracts and interpreting them. Can't we do that as a matter of law? Don't we do that all the time?
Correct, but the burden here is on the plaintiff to demonstrate that Levine's performance was just not part of the consideration in order to deprive the defendant of any opportunity to put up a defense.
But you have a remedy. You've sued Levine in Jersey. That's your remedy. That's what you agreed to. And I'm sorry if I can ask one more question.
Yes, of course.
I mean, just how do we deal with, or how is trial court supposed to deal with it? The litigation with respect to the APA is in New York. With the ICA, it's now in New Jersey. It seems that the parties created this purposefully to have this separation. No?
Well, that was the New Jersey venue clause or forum clause was contemplated in the event of there would be a specific dispute between Levine and Amertech. This is a dispute between Lancer and Amertech. If you look to the pleadings, it always speaks.
But it concerns
those
Levine's
parties.
performance, and Levine's performance can only be litigated in Jersey.
But that's not the issue, why, with respect to why the set-off was asserted here.
Okay.
All right, thank you.
Thank you.
Good afternoon, Steve Reinhardt, Troutman Sanders for the respondent, Lancer. I just want to add a couple of thoughts to the exchange that just occurred. One is that one issue we know is not in dispute. One of the issues we know is not in dispute is that Amertech has acknowledged both below and in its papers on this appeal, page 33 of its brief, that it owes the money.
Well, but their argument is that they owe the money under the contract, but I guess the payment was suspended or for lack of consideration based on Levine's failure to perform, the ICA.
Yeah, that's the current argument. And candidly, this idea of consideration, lack of consideration, wasn't really argued below.
Well, is it a lack of consideration? I mean, does that even sort of play into the analysis? Isn't it just a straight breach is what's being argued?
Yeah, what's being argued is that a breach of the independent contractor agreement by Mr. Levine is a breach of the APA by Lancer. So those agreements really are forced together in a kind of Procrustean way. They're really one agreement is the argument. And of course, Justice Ostrager understood well that, look, the presumption is separateness. You have separate agreements, separate purposes, separate terms, separate signatories. And the mere fact that they are part of a transaction, a sale of assets, as many other sales of assets that occur in the commercial world, there are bunches of ancillary agreements that go along with it. The only basis that we can see that Amertech can identify in the APA for their argument is the fact that all the exhibits are incorporated in the APA. And the exhibits are forms of various ancillary agreements and schedules and other items to be delivered at closing. That does not mean we ignore the parties, the terms, the purposes, and the separate executions, not to mention completely separate forum selection and choice of law. And as you point out, the issue of the ICA is being litigated as we speak across the river in Bergen County, and that'll get resolved at the end of the day. But one thing this court does not have to decide is, did Mr. Levine comply with the ICA? That's in another court, in another jurisdiction chosen by the parties. So the only analysis
And
is an analysis. Yes.
let me just follow that through to its conclusion. If Mr. Levine has not complied with the ICA, what's the remedy?
The remedy is what they are seeking in New Jersey, which is a clawback of payments that Amertech had made to Mr. Levine pursuant to the ICA.
And that would be a judgment against Mr. Levine individually.
That's correct. That's correct. And it's plain from both the APA and the ICA that there is no cross default. Lancer did not undertake Mr. Levine's obligations or guarantee his obligations under the ICA and vice versa. There's a reason why there's separation of parties. So the only basis.
So if they were right that there's a set-off, the set-off would be to the judgment that Mr. Levine has to pay? I'm trying to understand what remedy they think they get here. Or as you understand it, I know it's not your
As we
remedy.
understand, and
Yeah.
it's been a struggle. As we understand it, the monies that are owed to the company Lancer for the purchase of the assets, which, by the way, Amertak has had for 7 years, that money, they can stop paying that and set off against that monies they think they can recover from Mr. Levine for breaching the ICA.
It's like a double recovery if they're right.
There's a logical misstep in there. It doesn't make any sense. And the only, as the panel has pointed out, the only set-off right that exists under the APA, because everything is based on that, the only set-off right that exists is Section 10, which is the indemnification obligations of the seller, that being Lancer, based on breaches of reps, warranties, and covenants by the seller, that's Lancer. And if you go through the list of items that give rise to a right of set-off, they all relate to Lancer's conduct only. There's no mention of Mr. Levine. There's no mention of an ICA. And you can't, in essence, ignore the law of contracts and the plain terms of the agreements by simply saying, well, it's all one deal.
I'm going to ask you to wrap up, please.
Okay, just one last point as a housekeeping matter. There is a case that we cite in our brief called Kalanu. That, I regret to say, was cited in error, and I apologize for that, but that case was not cited or relied upon by the court below, and so there shouldn't be a reason to question the reasonableness.
And what page is that on?
It's called Kalanu.
Yeah. I want to make sure we don't cite it.
I don't have the page citation, but I can get it for the
No,
panel.
we'll find it. Thank you.
It's in our briefs, and I apologize
Okay.
for the citation. It's
We'll
an
avoid
error.
it.
Thank you.
Okay, thank you. The next case is Montera versus KMR Amsterdam. You can proceed.
Thank you. Good.
I thought we were done with these cases, right? Didn't Regina
Oh,
take care
I'm
of everything?
I'm afraid that we really are starting the third or fourth wave here.
Right. Right. But
It gives us a reason to come into work every day.
But Regina is the starting point here. I think both
Absolutely.
parties agree with that, right?
No, absolutely.
Regina is our guidepost, at least, right?
Absolutely,
Right.
absolutely.
And so under Regina, and I think this isn't disputed either, that this case, which predated the new rent law, that under Regina, this case is decided under the old 4-and-4 regime, as I like to call it.
Absolutely correct.
Okay,
I
so
don't
we
think
have
we're
a
having
four-
any dispute on that
Yeah,
one.
so we have a 4-year statute of limitations, and we have a 4-year look-back period to figure out what the base rent is.
Correct.
And this case was, forgive me, I just want to use our time well. This case was started in November 2017, right?
Correct.
So we look back 4 years before that, and the base date of rent would be, under the 4-and-4 rule, the rent in effect in November 2013.
That would be the base date for calculation of an overcharge.
Which is what? Which was what?
Less than the lawful regulated rent that was charged to the
Well,
last
that is
stabilized tenant.
But you're missing the point of Regina. Regina that is the lawful rent. You can't, if the tenant can't look behind that, then you can't either.
Well,
Isn't
that's
that
not
true?
exactly what we're arguing here.
Well, it sounded to me like you were arguing
To an
that when
extent.
you looked at the registered rent at 2009.
Well,
You can't do that, right?
well, That's when the apartment was deregulated. Let me refer the court to the first
I'm going to get to that
sentence.
too, because I have a question about that, but
Sure.
it doesn't matter. The rule of Regina straightened out that whole issue about whether you could look behind the rent that was charged 4 years before the overcharge complaint.
Right.
And it said that in the absence of fraud, you could not. And doesn't that rule apply equally to landlords as to tenants?
That is correct. Our argument.
So for you, in terms of establishing that you didn't overcharge, let's leave the fraud issue aside for a moment, wouldn't you have to show that any increases to the rent following 2013 were within lawful guidelines?
That was not the basis of this motion in the
That's
court
correct.
below.
I know that.
Yes.
I know that, but I'm asking you a different question.
I understand that.
You know,
I understand that, and without going into details, there's other litigation going on right now where that may or may not be being addressed. I am not all that deeply involved with that.
You mean not in this case, in another case?
Not on this record. Let us just say that. Let's say that
Okay, well,
there's
say
things
that.
that are not in this record that are going on.
Well, okay.
Good.
But that impacts on whether you've made a prima facie case.
Yes.
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 Sure.
But we're going back.
Okay, and
let
now-
me go back to the complaint.
Well,
And
before
to
we
the
go back,
statute.
on some level, we can't, I understand, you made a motion for summary judgment before these monumental changes.
Yes.
In the law and its interpretation, but that doesn't change what's necessary and how we have to look at this, right?
Well, that's correct.
All right.
But this is what we argued in the court below. This is what we're arguing here for one point of this. The first sentence of the former Section 2000 CPLR 213A, which we all agree or should agree that is applicable to this particular case because it arose well before the 2019 law, says as follows. An action on a residential rent overcharge shall be commenced within 4 years of the first overcharge alleged. The first overcharge alleged. We don't have that in this complaint here, and I don't believe that you can have that implied. The CPLR requires you to plead the facts upon which your claim is based. I don't believe there's a different rule in effect for landlord and tenant disputes. That was what our argument was. That is what the one remaining argument from that original motion really comes into play. Then, of course, there's the fraud issue, which I could speak about if you wish.
Well,
Yeah,
I
time's
think,
up.
I'm going to hold you to your time. You do have rebuttal, and I think your adversary has a lot to say about the fraud issue.
I'm sure he does.
Yeah. Okay.
Good afternoon. Roger Sacker, Newman Ferrara for Respondent Ken Montera. I do indeed have a lot to say about the fraud issue. The way that we read Regina and the way that we think it works is the first inquiry is to look at the rent on the base date, the rent 4 years prior to the filing of the complaint.
Right.
Okay.
And it doesn't matter. One thing Regina did make clear, because it was the source of the dispute in the appellate division, and Regina specifically said that in figuring that base rent, it did not have to be a registered rent, correct?
Correct.
Okay.
All right. Now, what we need to do, once we go back to that rent 4 years before, we then need to go, well, is that rent accurate or is it the product of fraud? Now, if the tenant can then show that there is an indicia of fraud,
So in this case, what would the tenant say is the indicia of fraud?
the failure to register the apartment and the failure to
Okay,
provide
and
him
there is case law from this department, pre-Regina, Nolte, for example, where failure to register units could constitute an indicia of fraud.
not only Nolte, but Kriesler v. BE
Okay.
Realty as well.
But the question is this: does Regina change that analysis?
No, because here's the key. The apartments in Regina, all four of them, Taylor, Radin, Regina, and Reich, all four of them were deregulated pre-Roberts based on DHCR guidance. That's why it says in the very first page, I think it's the first paragraph, says how do we set rents when the landlord's deregulated based on the DHCR pre-Roberts.
When was this apartment deregulated?
This apartment was deregulated in 2010, 1 year after Roberts, along with a number other apartments in the building. And oh, by the way, it wasn't registered in after March of 2012 when this court's Gersten decision went final. Those are keys. What my adversary is saying, he keeps pointing back to 2009 and saying, oh, look, this is the last registered rent. Well, all of you have issued opinions where last registered rents aren't reliable. They provided no evidence supporting that.
Yeah, but that's not the fraud that we need to look at, because otherwise, that wouldn't count in the 4 and 4 rule. We wouldn't even look at that.
Well,
you have to show a systemic fraud under Regina. They said it was hard to show in Roberts' cases. So why in this case would registration, or the lack of registration, count as a fraud when Regina said the lack of registration doesn't even affect what base state rent is under the 4 and 4 rule?
Isn't only a lack of registration. It's the failure to provide a rent stabilized lease as well.
It's all the same thing, isn't it?
Not necessarily.
In a certain sense, because the apartments were treated as luxury decontrolled.
Correct. Yes.
Right.
It's two different fruits from the same poisonous tree, let's say.
Interesting analogy. Okay.
Okay. But the issue here is remember, you have to look at the motivation. By failing to provide the tenant with a rent-stabilized lease, the landlord got to evade the waiver rule. And he also got to evade the J51 rider rule. Mr. Montera based on the failure to provide a J51 rider, as they acknowledge, Mr. Montera is entitled to a rent-stabilized lease in perpetuity.
For as long as his tenancy lasts,
Correct.
right?
So they could sit there, keep him in the dark. Maybe Mr. Montera leaves. Cross our fingers, Mr. Montera leaves. And oh, by the way, if we don't register his apartment...
I agreed with that argument at Regina at the Appellate Division, but that was not what ruled the day. My dissent was based on the lack of registration. I always thought that registration was the key to stabilization. But didn't Regina change that?
Pre-Roberts. Remember, pre-Roberts decision. The landlords in Regina, all four of them, didn't know they needed to register. And they didn't. And then they got sued. This landlord, this is a post-Roberts landlord, a post-Gersten landlord. Once again, just like, and I have read your dissent many times, that's the failure. This is this last post-Roberts question that we are asking the court to decide. Is the failure to register post-Roberts deregulation directly contrary to the Court of Appeals, and a post-Gersten failure to register directly contrary to this court's own opinion? Is that fraud? And we submit that it is.
Okay.
Thank you.
Thank you.
Before I get into the meat of this, I'd just like to thank the court for the use of its room and its time today. It's been a while.
It's been interesting today.
Yes, to say the least, to say the least.
All right.
To say the least. Mr. Montera first moved in March 2010 to the premises. That was a mere 4 or 5 months after the Court of Appeals in Roberts. So let's clear up that fact out of the way.
Yeah, but he moves in 2010. It takes you 2 years before you folks decide that it's time to register.
Sorry,
Why? Is counsel correct that we shouldn't look to Regina on this issue because there is a distinction? Regina involves pre-Roberts cases. This is a post-Roberts failure to register for a period of time, which, according to your guy, was an administrative error.
Right.
Isn't that sufficient as an indicia of fraud, at least at this juncture, because this is a motion for summary judgment before there's been any discovery?
Well, listen, that's another issue altogether, but We discuss in the reply brief the cases that he relies upon, some of which are post-Roberts overcharge cases, one of them being Nolte. In the Nolte case, there was substantial evidence of a landlord who didn't perform the renovations that he said.
Well, the IAIs, but we haven't had discovery in this case, so we don't really know what exactly occurred here. You moved for summary judgment.
Well, there have been an awful lot of, yeah, we moved for summary judgment, and
without discovery, correct? There's been no
Without
discovery on
discovery,
those
yes.
issues.
I mean, keep in mind, at the earliest stage, you know, there were other arguments that were predominant than what we do have here now. And, you know, we've charted this procedural course, and Justice Hagler, you know, for lack of a better word, allowed us to do it. And that's why we're here talking about fraud. I can't really talk too much about the lack of discovery to this point or in this action without going way outside the record and way outside my time. But if I could just have one final remark, is that Regina said we're talking about common law fraud. When you look at the affidavits here, nowhere close. You look at the court's decisions where they did find fraud or indicia of fraud, this court's decisions, nowhere close. Thank you very much.
Thank you. Okay, please step up on the case of People versus Keith Morris. It's a good argument.
Yes?
All of them. No.
Good afternoon again, Your Honors.
Good afternoon.
Megan Byrne for Appellant Keith Morris. In Mr. Morris's case, the evidence against him was not legally sufficient and certainly was against the weight of the evidence regarding his having caused a fractured ankle of the complainant. So to begin, this is a preserved issue. At the motion to dismiss, counsel specifically said that the prosecution failed to prove that it was Mr. Morris who caused any injuries to the complainant. There's some unique hallmarks of this case regarding the cause of physical injury of the fractured ankle. The first is that there was no medical testimony in this case at all, so no doctor spoke about what caused this fractured ankle.
But we do have some facts, right? We know that the defendant grabbed Mr. Finch in a chokehold, correct?
Yes, that the complainant stated
and
that.
Mr. Finch was then, I guess, thrashing around, and in that instance, presumably there was a fracture to his ankle?
So that is the version said by the complainant. What's very significant here is also, according to the complainant himself, the complainant had a pre-existing fractured ankle, which he had sustained just prior to this incident.
Well, I'm sorry, go ahead.
What do you mean by just prior?
It's unclear because the complainant was unclear. What we know, or what the complainant testified to, is that it did happen in the time he knew Mr. Morris. He knew Mr. Morris for only, according to him, 2 to 3 months at the time that this incident happened. Mr. Morris put it at about a month ago that the ankle had been fractured.
But isn't it part of the record that the ankle had healed, and he was walking around without any pain prior to this incident?
In that the complainant himself said he felt like it had healed. He said he couldn't remember even when that healed. We know that Mr. Morris visited him in the hospital in these, let's say, 2 to 3 months whenever this ankle was fractured. We also know that when he went to the hospital this time, that he was told he needs to wear a cast for 5 months because he has a fractured ankle. So in order for the complainant's version to be correct, he would have had to have fractured an ankle sometime in that 2 months. It healed. And then coincidentally, Mr. Morris would have had to have fractured his ankle again. And I don't think...
Counselor, I'd like to go back to that because the evidence also indicated that right after the incident that he immediately felt pain. He went to the hospital. He required hospitalization. And then if we go back, the evidence also indicated that he was in the hospital 3 months prior and that it healed. Wasn't the jury entitled to credit that testimony?
Yes, except that there was no, while there was hospital records about him visiting this time, there was nothing regarding the prior injury at all. The only reason it came out is because the defense attorney asked the complainant, didn't you just fracture your ankle and wasn't it fractured in the same place and hadn't Mr. Morris visited you?
Yes, and he said, yes, he was in the hospital.
Yes.
That defendant did visit him and it healed. And the bottom line is that after this incident, he felt pain. He went to the hospital. And he went to the hospital because the pain and the swelling increased. And I just want to go back. Wasn't the jury entitled to credit that testimony, to say, yes, I was in the hospital 3 months prior. I had a prior injury, but it healed.
The jury, his testimony...
Can you answer that question for me, counsel?
I'm sorry?
Can you answer that question? Wasn't the jury entitled to credit that testimony?
It was entitled to credit the testimony, except that doing so, obviously it did, to some degree to sustain the conviction, but doing so, the argument was against the weight of the evidence, where you have a complainant who said, he was iffy on the amount that was stolen. It varied by thousands. He said he went to the hospital right away because it hurt. He said he went within an hour. In fact, he went 12 hours later, according to the...
But, Counselor, I'm sorry. The issue is intent to cause physical injury. So the defendant puts Finch in a chokehold. Finch is thrashing around, hurts himself again. We know that he's scared. He urinates on himself. Your guy is a big guy. Finch is a small man. So didn't the jury have sufficient evidence to find, in fact, that defendant intended to cause Mr. Finch physical injury based on the altercation?
Not just the intent to cause it, but that he actually caused the fractured ankle, and that's what's important here, is that not just pain from an ankle already fractured, but that he himself fractured his ankle is the issue that we're disputing.
One last question is that I saw in your adversary's brief that they rely as well on the chokehold. Doesn't the chokehold in and of itself constitute the physical injury that is necessary for an assault too?
A couple things. The prosecution never argued that. Strangulation can be a physical injury if there's testimony that there was a pain associated with it that was very severe and a prolonged strangulation or failure to be able to breathe, but that wasn't something the prosecution argued below.
Okay, thank you.
May it please the court, Karen Schlossberg for the people. Good afternoon. I just wanted to point out on preservation that the legal sufficiency arguments are not preserved as outlined in my brief. There was no argument below about the intent of the defendant, and the causal argument that's being advocated on appeal was not raised before the trial court. There's no question here that this defendant intended to cause injury when he attacked this man who was older than he was, sickly, much smaller, half his size, put him in a chokehold. As I think someone pointed out, Mr. Finch was flailing around. He hit the wall. They hit furniture. They fell to the ground. The defendant fell on top of him.
Is defense counsel right that it has to be shown that defendant intended to cause fracture to the ankle, or we're talking about physical injury here? What should we be looking at?
The causation he does not have to have intended to cause the actual injury that happened. He has to have caused. I'm looking for the exact quote. He set into motion a chain of events from which some injury was foreseeable, and so causation can be established even if the actual injury suffered and the exact manner by which it came about were not foreseeable. That's People v. Morrow. That's a direct quote from People v. Morrow. He's literally almost twice this man's size, and he's attacking him in a chokehold. They're flailing around. He falls on top of him, and even at that point, when they're on the ground, after Finch has hit the wall and the furniture, even then, when defendant falls on top of him, he still doesn't release him from the chokehold. And the idea that he wasn't intending to cause this physical injury is hard to understand, honestly. And the causation aspect as well. You know, I think the points were being made very well from the bench, so I won't go into it too much. But his testimony was very clear that his prior injury had healed. All the people, and the jury didn't have to rely on Finch's testimony alone. You had the testimony of the people who work at the home where he was residing, who were so concerned about his condition
What is
after
the
the
medical
attack.
proof that you have that he sustained a fractured ankle?
I'm sorry, say that again, Your Honor?
Medical proof?
There was not medical testimony, as my adversary said, but there were medical records put into evidence. He went to the hospital, and he definitely had a fractured ankle, and the doctors were able to document that it was swollen and very tender and fractured. He clearly wasn't walking around on that and limping before this assault, and his testimony was that the pain and the injury was during the assault, and I think the evidence surrounding from the other people made that very clear and corroborated
There's
that.
also testimony that it immediately, that it swelled.
Correct.
That it hadn't been swollen when he was first confronted by the people in the building, and that over time, immediately following the accident, it swelled, and that's why he went to the hospital.
Right. I mean, EMS was summoned initially when he refused to go to the hospital, but right after the assault, and even they could tell that it was swollen and tender. But then over the course of the next group of hours, it got worse and worse. His condition, he couldn't walk on it anymore. And then when he finally went to the hospital, so yeah, the issues are not preserved, but I would also
Did you argue below that the chokehold in and of itself should be should satisfy the physical injury element?
Well, no, because there was no argument below. The defendant didn't make a trial order of dismissal on the ground that there was lack of evidence of physical injury. So there was no discussion about what the injury was.
One way or another.
It wasn't discussed. And counsel below.
Not even before the jury? You didn't, I mean, you had to,
to be honest, Your Honor, I don't recall exactly. I don't know that was ever raised.
That's an element of the crime. You'd have to establish that before the jury.
Of course. Of course he would have argued in summation about the injury, and I don't know if the choking itself was ever discussed as part of that. I don't remember.
Would you agree that if you didn't raise it below, then that part of your brief, which relies on that, is something that we really shouldn't take into account?
I'd have to think about that more, Your Honor. To be honest, no, because their argument is unpreserved as well. So they're arguing a lack of it. They're saying the evidence doesn't prove intent. It's unfair to hamstring us in our response by what was not argued in response to an argument that wasn't made below. Their argument on appeal is that there was not.
I'm not sure about that. If they're saying that, all right.
I'm not sure. I don't know what the prosecutor would have said if the defendant had made that argument below.
But your best argument is the fractured ankle.
Of course. Yes. And I think that's there's never been an argument, even on appeal, that the broken ankle did not constitute physical injury. Just that there was no intent to cause it, which I think the evidence makes clear that there was.
Well, and it wasn't caught. It pre-existed, is how I understood the argument.
The argument on appeal is that there was a pre-existing injury. They didn't make that argument below. Below, they said the argument was that because Mr. Finch waited so many hours before he went to the hospital, it could have been that some intervening event occurred that caused the injury.
Okay, thank you.
All right, thank you very much.
All right, Counselor Rebuttal.
So I'd like to briefly cover the excessive sentence request here, but I did want to make clear that we advanced two arguments. One, that there was no intent to cause physical injury, and I would agree, Your Honor, that that intent doesn't have to be for any kind of specific injury. We also separately argued he did not actually cause the fractured ankle, that was a pre-existing condition. Regarding the excessive
Even if it was a pre-existing condition, let's assume that the earlier fracture had not fully healed. If your client aggravated that injury, doesn't that satisfy the elements of assault too?
Well, I think it depends on what the prosecution is relying on. Here, and I believe it's page 330 of the transcript, the prosecution relied on the fact that he had a fractured ankle, and so it wasn't relying on the substantial pain, but relying on the physical impairment part of physical injury. So to that extent that the fractured ankle is a physical impairment, it seems that Mr. Morse would have had to have actually caused that. If it was already fractured and then Mr. Morse caused it to have even more pain than a normal ankle would have had, then our argument would be that the prosecution should have argued that it was substantial pain and that was what the physical injury was. Just briefly here, as far as mitigation in Mr. Morse's case, here he got 14 years where the minimum was 12. And that was, it's a pretty high minimum already for an assault too, and that's based on two things. One, his history in which he had prior convictions, but it's really important to note here, those convictions were from 1983 and 1995. This happened in 2016. So they were 20 years old and more at the time. And then of course there's the enhancement because this is an age-based offense where someone over the age of 65 is the complainant and the other person is 10 years younger than them or more. That's where it's applicable. Here, the complainant was exactly 65, and Mr. Complainant was just 13 years younger than him, so it's not the average case that the statute applies to.
Thank you. The next case is People versus Sanjay Tripathi. Okay, you can proceed, Counselor.
Thank you. May it please the court, my name is Arnold Levine. I represent Sanjay Tripathi, the appellant. He was the defendant below. This court should reverse Mr. Tripathi's convictions for several reasons, taken individually and cumulatively. I don't expect to get through all the issues raised in the brief, but I stand firmly by all of them. First, although the suppression court suppressed Mr. Tripathi's personal belongings seized from his hotel room, the court failed to suppress evidence of the complainant's pink purse and its contents, also seized from his hotel room.
Counsel, was that pointed out by defense counsel that you're talking about the purse, correct?
It was the purse. Well,
but was that pointed out that there was a mistake there, or nothing was said about it?
Well, we don't know whether it was a mistake. The defense lawyer specifically said that he moved to suppress everything. He mentioned the pink purse repeatedly in his argument to the court after the hearing. The court, in its detailed decision following the hearing, in the 3 weeks after the hearing's decision, noted defense counsel was moving to suppress everything from the room, the same language that the defense counsel used, and yet she suppressed only Mr. Sanjay Tripathi's personal belongings. We don't know whether it was because she thought that the complainant's personal belongings weren't subject to suppression or something else. But the CPL makes clear that once the request for relief was made, either the failure to rule was an implicit denial, or the failure to rule was an implicit denial, and no exception needs to be taken. No other action needs to be taken to preserve the...
So it's your position that you preserve the argument?
Absolutely. Okay. Furthermore, Your Honor, the lower courts erred in applying the rape shield law to deprive Mr. Tripathi's counsel of favorable information in their possession. Specifically, Judge Obis erred in entertaining an ex parte motion, application by the people, and including that information could be kept from the defense counsel. Moreover, Judge Edwards, the trial judge, exacerbated Judge Obis's error when she completely failed to exercise her own discretion. In fact, it seems that she failed even to review the messages until midway through trial. And then that was further compounded when, in the middle of cross-examination, she allowed the prosecution to meet with their star witness. As defense counsel was cross-examining the complaining witness, the judge took it upon herself to have a sidebar and suggest to the people that they meet with her privately in her robing room to review documents, that same information that had never been provided to defense counsel. Third, the trial court erred when it allowed the prosecutor to elicit details of several prior consistent statements allegedly made by the complainant, both through the complainant and through Sergeant Shack, Detective Jones, and the doctors. Also, Your Honor, the impeachment of Mr. Tripathy by omission was improper and prejudicial. To go back then to the suppression issue, the court rightly decided that there was a patent violation. When the police entered Mr. Tripathy's hotel room without a warrant, after removing him from the hotel room, he exited on his own, he was handcuffed, he was placed under arrest, and the officers nevertheless entered the room. The judge clearly decided that correctly in deciding that there was a patent violation. However, when she decided to suppress only some items and not the others, that was an error of constitutional dimension. The contents of that pink purse was pivotal to people's case. They mentioned it, they went back to it 2 different times in summation. They told the jury that it was significant.
Well, but how was it significant with respect to, for example, the assertions by the complainant about being strangled and physically abused? How would contents of the purse really have anything to do with the other aspects of the trial?
Well, Your Honor, that's conflating 2 issues with all due respect. The physical assault, there's no question a physical assault happened. She was punched, she was slapped, she was physically assaulted. That amounted to a 3rd degree misdemeanor assault. However, she claimed that happened in the midst of a sexual assault, which we said did not happen.
But how does a purse tie into your defense?
Because the defense was that he paid her for sex, that they had an agreement about money. In fact, in the first communication.
And the purse would show what? I mean, so what?
The people used the purse, the contents of the purse, which was, according to Detective Jones, who didn't vouch for the purse and didn't take a photograph of the purse or its contents, but nevertheless, they elicited from Detective Jones that the purse contained a few $100 bills. Mr. Tripathy testified that he paid her $1,500, that he took out money from the ATM at least twice. That was on video during the course of the date, so that's uncontradicted. And they could see the denominations in his hand that he took out from the ATM, and apparently they didn't match what the few $100 bills that Detective Jones said was in the purse. So the people relied on that in summation to say that money did not come from Mr. Tripathy, that he's lying when he says he paid her for sex. So without that purse, the people couldn't have made that argument. In the meantime, Ms. Risdal, the complainant, did leave with a much larger bag. Mr. Tripathy said that she threw the money in that bag. Nobody ever checked that bag. Nobody ever searched it. Nobody knows what the contents of it were. But the pink purse, the people used to try to prove that Mr. Tripathy, in fact, did not pay her for sex. His whole defense was that this was a consensual sexual relationship.
Oh, so is it your assertion that because you pay someone for sex that you can beat them up and strangle them and do all these things?
No, Your Honor. It was that there was consensual sex, and then after the consensual sex, which got a little bit rough because she also said that she was into being submissive, while he was into being dominant, that it got a little rough. There was some slapping, there was some light choking, but then when she went to the bathroom to wash up, she saw marks on her. She was supposed to see another guy named Kevin that night, who she met from the same site, and she was hoping to get paid very much. When she saw the condition of her face in the mirror, she couldn't do that. She couldn't even go, and she knew she wasn't going to be able to meet other people the day after or the day after that. She was seeking money from everybody from that site. Okay, so when she saw that, she tried to extort Mr. Tripathy. She said, I can't go out on dates anymore. You have to pay me more now. You'd already given her $1,500. He'd shown her his ID. He had talked to her in the hotel bar and showed her his driver's license, which is on video. And she threatened at that point to disrupt his career and his personal life. She was extorting him at that point in time. That's when he flew into a rage, and that's when he assaulted her. But that assault was separate and came much after this consensual sex that had occurred. So, Your Honor, next then is the messages. It's a little dicey for me to try to argue this because I got to see the messages because a clerk of the court gave them to me as part of the court file, but then it was later determined that he shouldn't have done that. I made a motion to your honors. You should have them in camera.
We do have
review.
them. We have them.
Those messages should have been disclosed to the defense. There should not have been an ex parte motion to Judge Obis. Judge Obis should have had them disclosed to the defense so the defense could make the offer of proof necessary under People against Williams. Okay? People against McCrae, may I finish, Your Honor?
Please finish your point.
Under People against McCrae, the Court of Appeals recognized that admissibility cannot definitively be decided when defense counsel isn't given the items he needs to make an offer of proof. So in this case, defense counsel, both prior counsel and the trial counsel, didn't even know these these messages existed. The ex parte motion kept them from him. He didn't know until that the ex parte motion had even been made until right before trial when the prosecutor alerted the trial judge to it. He never got to make the required offer of proof under People against Williams because he was never given the material required to do so. Had he been given those materials, he could have made a very detailed offer of proof that would have been impossible for the judge to deny. If you look at those messages, it's impossible. The messages from the day of and the day before and 4 days before, it's impossible not to see a pattern perfectly consistent with Mr. Tripathy's testimony, and yet Mr. Tripathy didn't even know what was in those messages when he testified. Your Honor, given that I'm already out of time, I'll, I guess, resume on rebuttal.
Okay, thank you.
Thank you.
May it please the court, Luis Morales for respondent People. To start with respect to the pink purse and Justice Singh's question about so what, I think that really gets to the heart of the issue. This is not a simple he said, she said case. There's significant independent corroboration of the victim's story, beginning with the text messages, both sent to her second date that evening, as well as to the fictitious babysitter, unexplained. The next door neighbor hearing, or the next door hotel room neighbor hearing, screaming and running for help. The delay in opening the door when the police came, and so forth. I don't want to, it's all in the point. And the mention of the pink purse was not made, the contours of the suppression hearing were set forth when counsel said, at the court's request, laptops, mobile devices, and the cell phones. The pink purse was mentioned because that was the explanation that the detective was giving for his entry to the room. I went in to get the purse and return it. So that was not ultimately subject to the hearing, and if counsel was under the impression that it was up to him to bring that up. But again, it boils.
To what extent did the prosecution rely on the contents of the pink purse in making its argument that the elements of the crimes were established?
Well, I mean, counsel is certainly correct in noting that that the people did distinguish the amounts that were in the safe and that were taken out from Detective Jones's testimony of a few hundreds. Now, that, of course, that there were a few hundreds doesn't exclude that there was other bills in there to begin with, but that really wasn't the issue. That wasn't really central to what the jury was deciding here. What the jury was deciding what happened in that room, and all of that independent evidence that I listed before is really how they came to that conclusion. Turning next to the messages, the first, starting even from the outset, and the prosecutor's trying to do the right thing here. It's her position and the people's position that these are not relevant and that they do not have any bearing on innocence because these are conversations with other people on a dating website. Following that, when counsel does make a specific request for relevancy, he wants the messages about sex for money and BDSM. You have the messages, and to the extent of the BDSM, they weren't going to find anything about choking or money for choking or punching in those messages. And she says, let's see how the testimony shakes out before we make any final decision about money for time. And this gets us to the ex parte conference point, when that actually occurs, the judge having the messages herself, which, because the people have disclosed and made this proffer, makes a determination that the record needs to be corrected, the fact finding needs to occur, but balanced against relevancy, that this is not a trial about her conversations with other people. And of course, her conversations with defendant were disclosed. The jury had that. The jury knew she's on this website, that she lists herself as high budget, that she's asking for people for money for romantic relationships that could include sex, and that she'd asked other men, and that she had a second arrangements date set up at night. So the messages, at best, are cumulative impeachment evidence. I'm not sure if there are a number of issues, so if there's one in particular Your Honors would like me to address.
We'll ask you if that's the case.
Okay.
Right. I'm not shy.
Yeah, no, and so beyond that, with respect to the impeachment on silence, the court again intervened despite a general objection. She picked up on the fact that this could be considered the first question, which she sustained the objection to, which is, did you say, oh my gosh, thank goodness, when the police officer showed up your door? Now that is implicating the police are present, that implicates the right to silence. But when there's a significant amount of time asking about consideration and thought process, that was a distinction, and the court was making sure to parse that carefully on either side. Beyond that, the summation was a fiery back and forth where the word liar was levied both ways. There were no objections, there were no objections to the bulk of the comments, and those objections that the court did sustain, they moved on, and so you don't have this pattern of obdurate remarks.
Yet the prosecution did make remarks like telling the jury to do the right thing. You would agree that would be inappropriate, wouldn't you?
If you're saying do the right thing is to convict, do the right thing, convict, sure, but do the right thing, consider the evidence.
I don't know what that means. What does it mean to do the right thing?
To do the right thing, which was what she followed it up by saying, which was to, if the evidence proves this beyond a reasonable doubt, to convict. If the panel has no further questions, I ask that you affirm. Thank you.
Thank you. Counselor, you have rebuttal.
Your Honors. There actually was no corroboration of a sexual assault. There was corroboration only of physical assault, which Mr. Tripathi conceded had happened in response to the extortion attempt well after the consensual sex, which was bought and paid for, had already occurred. In fact, the neighbor, the woman in the neighboring room, Tasha Sullivan, I believe was her name, her timeline coincides with Mr. Tripathi's timeline, not the complainant's timeline. The complainant said that she had been assaulted and raped almost immediately upon entering the room, which was shortly after 10:30. Ms. Sullivan was up and awake, went to bed at 11 o'clock, couldn't fall asleep, was looking at the clock, and didn't hear a sound from the next room until midnight. Midnight, that's almost an hour and a half later. That does not corroborate the complainant's version that she was physically assaulted and thrown around the room and raped violently for an hour and a half up to that point. In fact, it coincides with Mr. Tripathi's timeline that the sex had already occurred by then. She had gone in to wash up, returned to the room, tried to extort him upon seeing her injuries and saying that she was going to ruin his life, and then he flew into a rage as a result of that. Also, there are the forensic evidence, the biological evidence, also didn't corroborate her. There was no blood, although she says that she was beaten senseless, bleeding from her nose and her mouth, and then was forced to give him oral sex. There was no blood anywhere on his body from her, on his penis, on his anus, on his legs, in the area, in the groin, no place blood. But there was amylase, which was consistent.
Was there corroboration of strangulation?
There was some marking on the neck.
Would that suggest maybe he was choking her while he was doing whatever he was doing?
Well, it's consistent with the defendant's version that it happened afterwards as part of an assault. Also, that there was some light choking during the sex, which she had consented to. In her message, you'll see that she time and again says that she's a very willing participant as a sub, meaning submissive, along with somebody else who likes to be dominant. In addition to the various, she asks literally every single person for money, and she refuses to go on dates with people who can't meet her financial requirements. She turns down lots of money. She turns down $400, $500. If they can't pay $1,500 for the night or $1,200 for the night, she says, best of luck to you. That's consistent with Mr. Tripathy's testimony that, in fact, there was payment that night, that there was paid for sex, that he went to the ATM twice during the date. Who goes to the ATM twice during the date if it's not for the date? He paid for everything by credit card. And then she says she had no idea what any of that was about. So everything that he said was consistent with what's in those messages. Those messages should have been turned over so that the defense counsel can use them on his own case and to cross-examine her and discipline her, as the Court of Appeals said in People Against McCrae.
Thank you.
Thank you.
The next case is Kosovsky. Sorry if I mangled that. You can proceed, Counselor.
May it please the court. Good afternoon, Your Honors. Stephen Kirkpatrick for the appellant. The issue in this appeal is very simple, and that is in a partition action to compel the sale of a cooperative apartment, does the accounting for income and expenses have to wait until after the sale, or can it proceed?
Isn't there a case law that supports that position? I mean, the cases go both ways, correct? In terms of when the accounting should take place,
Right.
correct?
And the most recent case, Your Honor, is Lane v. Tyson. This court decided that case in 2015, and the court clearly said...
But what I'm suggesting is cases go both ways. So in this case, assuming that the accounting can take place before or after, why in this case should there be a partition and then the accounting?
Well, the reason in this case is the same as in Lane v. Tyson, which is the most recent case, holding the same as we argue, and that is because until the sale price is known, you cannot complete the accounting. In addition, in this case, the appellant, my client, is 97 years old, and...
She 97 or 96?
97. She turned 97.
When did she turn 97?
I'm not sure of the exact date, but it was after the appeal was perfected, but before today. So she's now 97. It's her wish to sell this apartment, to take half of the proceeds that she's entitled to, and to gift them to Columbia University in honor of her deceased husband. And it's very important to her that she do that during her lifetime. And that combined...
We don't have in the record what she wants to do with the proceeds, do we? Is that in the record? It doesn't even matter.
It doesn't matter, Your Honor. That's correct. But what's in the record is that she's 97, that she wants to sell the apartment, and there's no way, as this court determined in deciding that the accounting should be done after the sale, there's no way to know and to complete the accounting until you know the purchase price. And
Now,
that's
there's
what
an
this court-
allegation made by your client, which is denied, that she was forced out of the apartment. Is that correct?
That was an open issue. Her claim was that the locks were changed and she was not able to use the apartment as she desired.
And it's still her position. And was she living in the apartment before that time?
She was not living in the apartment. There was actually recent discovery on that issue outside the record, and that issue may be closer to resolution as a result of the discovery.
Okay.
So that is, I can answer any other questions, but that is really our argument, that the court should follow the most recent decision, the 2015 decision of this court in Lane v. Tyson, that there's no need to wait until that the...
Do we need any hearing on the issue raised by the daughter that there was a side agreement, if you will, a side oral agreement, that she could live there with her own daughter until she decided that the place should be sold?
Your Honor, we don't need any hearing because this that's the most that was claimed, and my client vigorously disputes that, is that there was an oral agreement. There is no written agreement. There was no evidence of a written agreement submitted in the court below, indicating that there was a written agreement to that
And the
effect.
trial court, as I recall, sort of rejected that argument as well. Isn't that correct?
Yes, Your Honor, I believe
Well, the
so.
trial court's decision was predicated accounting before partition, essentially. Correct?
What the trial court's decision said is that the accounting should be done before the sale.
Correct. Okay.
Thank you, Your Honor.
Thank you.
Good afternoon, Your Honors. Following up on a few points that were made, and then I'll go backwards if need be. I don't believe that the trial court decision found that the constructive trust argument was incorrect. What they found is that it was insufficient on a motion for summary judgment. But we're not appealing.
Rejecting the argument, right?
I don't believe that they rejected it. I think she said that it's uncorroborated to support her motion for summary judgment and therefore denied her motion. But I don't think that there's a decision that her counterclaim still exists. There's no decision on the counterclaim. But the argument is that doesn't change their motion for summary judgment. She has an argument that there's a constructive trust. That fact must be viewed in the light most favorable to the non-moving party. So I know we glossed over, and the appellant didn't totally argue. She doesn't have the right to a partition, an absolute right. She has the right to maintain a partition action pursuant to the RPAPL, but she doesn't have an absolute right to actually partition.
So in this instance, didn't plaintiff, or hasn't plaintiff demonstrated her right to partition and possession of the apartment?
I would submit no, Your Honor.
And the reason is because there is this agreement essentially waiving partition? Is that the basis for it?
There is a basis that there's a waiver of partition, but the constructive trust is always an oral agreement. If it was written, it would be a breach of contract, not a constructive trust. It's an equity argument, and she is maintaining that she owns or is entitled to a larger percentage than what appears on the cooperative shares. That goes...
But based on what? What's the evidentiary basis for that statement? I can say, a dog's a cat, but that doesn't make the dog a cat, right?
You are correct, Your Honor.
So what's the evidentiary basis for that statement?
Well, I think that there was evidence in the record regarding... It's kind of a twofold answer, so I'll give it to you a little bit two ways. One, this was all pre-discovery, so we have to understand that there was no paper discovery, no depositions, nothing completed at the time of this summary judgment.
But it's your client making the assertion, so presumably,
Correct.
Presumably she has evidence with respect to this alleged oral agreement.
Her position is that was in her affidavits also. She entered into an agreement with her parents before the purchase of this apartment. She had owned a separate apartment in the building. Her parents wanted her to have a bigger apartment, so she entered into this agreement with them. We argued, and the evidence shows, and her argument is that her father's will, although we're not dealing with a probate, and we understand that, is supportive of the fact that her father followed through with the agreement and that there were no issues. She's also saying, and has said all along, that the agreement was that she would live there exclusively. The application to the co-op, which is in the record, says it's to be exclusively occupied by her and her daughter. There's actually on the first page of that closing statement, which is in there as well, I think starting at page 84, it says, your apartment for Karen, who is the defendant. It was always supposed to be her apartment. There was a question raised, and there was an issue about the forcible exclusion and the keys. New evidence has come out in depositions that does, I believe, and I think it was conceded, it kind of takes care of that issue. I don't believe that that's totally accurate here. That is outside the record, but it's extremely relevant in this case. The court held that it was premature to the parties to determine their respective to grant this motion before determining their respective rights.
So your adversary argues, and sort of kind of makes sense to me, that we're talking about accounting, and how can you have an accounting without knowing how much the proceeds are for the court to properly, because there has to be some kind of distribution, right?
Well, the issue, that's
Are you going to base it on hypothetical amounts? I mean, how are you going to do it without having that number?
You don't need the sale price to determine an accounting always. if I show that in the course of the sale price, assuming there's a determination of a 50-50 split, I'm making that assumption just for the sake of this, you would then take it would be split 50-50. An accounting would be, okay, I put this amount in that's in excess of my 50%. Therefore, if I spent $100,000 and I should have only spent 50, you owe me 50. That has nothing to do with the sales price.
But here's the thing, what you're talking about is money, right? And so unless your client is making a claim that she is entitled to continued possession, then why shouldn't we sell it first and do the debits and credits afterwards? If all we're talking about is money, how to split up the money, assuming you can sell the apartment for a fair market value.
We are not talking only about money. Her claim is for a title in its entirety. Her argument is, and her claim is for 100% title.
Which is completely inconsistent with the documents, other than her assertion of an oral agreement, in effect, waiving the right to partition.
I think I don't agree with that, Your Honor, respectfully. I think that goes against the whole idea that this motion and the holding of this motion was that it was premature. The judge didn't say you're not entitled to this long term. He said it's premature. And it's premature because there had been no discovery done. There's no ability for us.
What discovery would you offer that would go to this issue?
Well, the deposition was extremely relevant.
Deposition of a 97-year-old woman you're gonna talk, how long ago was the sale?
They purchased it in 1990.
So you're gonna depose her about
2001, I'm sorry.
I'm sorry, how many years?
2001 it was purchased.
2001, so a long time ago, right?
19 years ago, yes.
So you're going to depose a 97-year-old woman and ask her what happened, whether or not there was this agreement?
I did depose the 97-year-old woman.
Right.
I have done that since this. We did paper discovery. There were things that came out. There's a question as to the wills. There's a question as to filing. This all goes, though, to that the judge was well within his discretion to say that this was premature, that discovery should be borne out before you take my client's rights away from her and you force her to sell her sole residence. The other problem with the accounting before the sale argument, the sale before the accounting argument is, this is my client's sole and primary residence. The appellant doesn't live there, so of course she doesn't care if it's sold because it's money, but you're going to hold all of my client's money until what? So she has nowhere to live and no money to do. There's an extreme prejudice there, and that's what the cases say. If there's a prejudice, it doesn't make sense to do. The cases do go both ways, and they're fact-specific. The judge did not abuse his discretion in finding that, given the factual circumstances here, that's the appropriate way to go. And Lane v. Tyson doesn't really contradict that, although appellant would like you to believe that. The facts there, they said there was just no question of fact that precluded the motion. That's not what we have here. That's not how the judge decided the motion, so it's not factually relevant. Unless your honors have any further questions, I'm happy to stand on my papers.
Thank you.
Thank you.
Any rebuttal?
No rebuttal, Your Honor. Thank you.
Thank you. All right, the next case is People versus Gamble.
Good afternoon, Your Honors. May it please the court. My name is Mark Zeno, and I represent Appellant Sherman Gamble. The people did not prove Mr. Gamble caused physical injury with a dangerous instrument, and even if they did, that injury barely met the statutory threshold and did not warrant the maximum 7-year sentence. Even if complainant's account is believed, the only evidence corroborating her claim of physical injury with a rolled-up magazine or newspaper was what appears to have been a cut or paper cut to her lip. Subjective complaints of pain are not enough to establish or prove physical injury.
Was there choking here which caused bruising?
There was choking, but
Did it
my
cause
client was
bruising?
charged with strangulation but acquitted of strangulation.
Did it cause bruising?
Did the choking cause bruising?
Yes.
Yes, the choking
And are
caused
there
bruising.
photographs documenting injuries
bruising?
caused by the defendant?
The bruising is a separate issue. The bruising is the question is whether the dangerous instrument caused injury. He was charged.
So let's get back to the newspaper and the shoving it down her throat. She testified that it made her throw up. Isn't that objective evidence of physical injury more than just a cut on her lip?
No, it's not. Triggering a gag reflex is not injury. I mean, injury is something that lasts, that it's impairment that continues, it's pain that continues.
Counsel, what about the fact that she also indicated that she bled from her mouth, that her throat ached and felt sore the day after, as if something was dislodged in her throat, and she had difficulty swallowing?
Can you repeat the last?
Yes, that she had difficulty swallowing.
Right, and there were allegations that Mr. Gamble choked her, and if that was a result of the choking, which he was acquitted of, and not the paper, the newspaper, then he was not guilty of second-degree assault. There was no evidence that the newspaper went down her throat. She didn't testify that it went down her throat. So there's nothing in the evidence. There's nothing in the evidence from which it can be inferred or deduced beyond a reasonable doubt that those injuries were caused by the newspaper. And that's what elevates this crime from an A misdemeanor, if it's just an injury without a dangerous instrument, to a violent felony for which my client is serving 7 years.
Counsel, what
So that
about the
connection-
fact that she also indicated that the pain felt like a 6 out of a 10 when she was at the hospital? And then you also have the medical records as well, along with the testimony of the doctor and the police. Can you address that, counsel?
Yeah, and again, that's the same point. She did not specify she did not specify that pain was caused by the newspaper and not the other injuries that she received, which would have supported, again, only a misdemeanor crimes and not a violent felony. She did not testify that that was the cause. She cited a number of factors, and the people had the burden of proving that those lasting injuries were caused by the newspaper. And just building on that, she also testified when she left the hospital that her pain was a 0 level. And there was no testimony that she experienced pain from the newspaper at the time.
Was there testimony with respect to her eating habits after the injury or after the incident?
I'm sorry, can you repeat that?
Was there anything about how she had to eat after the incident?
Again, there may have been testimony, but it was never tied to the newspaper, as opposed to the strangulation, which she claimed that she passed out as a result of the strangulation. And the jury acquitted my client of those charges.
Okay.
I'll save the rest for rebuttal.
Thank you, Counselor.
Brent Ferguson for the people, and may it please the court. Your Honors, the people
So
proved...
Here's my first question to you. How do you reconcile the acquittal for strangulation with the people's claim that the injuries from the assault were physical injuries in order to get an assault too?
Well, Your Honor, a couple things here. The strangulation occurred at a different time than the newspaper magazine being shoved down the victim's throat. So I don't think there's any...
Yeah,
Sorry?
you didn't argue that the strangulation occurred at the time that she claims he shoved the newspaper down her throat?
At trial, the strangulation, I believe, was said to occur on March 1st, and the assault we're dealing with here is on March 3rd. And also, I don't believe that defendant has argued that there's any kind of inconsistent verdict. I haven't reviewed the law of strangulation recently, but I believe there's something required about difficulty breathing, and so I don't think that there's any kind of inconsistency with the assault involving a dangerous instrument or the strangulation. I'll say quickly here, there's no question that this assault happened and that happened with a dangerous instrument. There was detailed testimony from the victim about the defendant pinning her down on a couch, punching her, kicking her, and then shoving this newspaper or magazine down her throat. There are also photos that corroborated those injuries. There is testimony from a police officer who saw her the next day and testified about her physical state. And of course, there is testimony from a doctor who saw her at the hospital. Now, there are three different types of injury that the people showed with regard to the physical injury that the victim felt because specifically of the newspaper or magazine. And this has nothing to do with the choking or anything else like that. First was her description. And as Your Honor mentioned, she said that she had a pain level of 6 out of 10. And when she described that, she mentioned her throat. Of course, the defense argues that that could have been related in part to choking, but the defense there is trying to take advantage of the fact that defendant choked her first before he shoved this object down her throat. I don't think that's a proper argument to make, and at the same time she was telling the hospital about this pain in her throat and the level of 6 out of 10, she also talked about something being dislodged in her throat. And I don't think there's any viable argument that that would come from the choking. That certainly came from the paper shoved down her throat. We also have objective evidence on top of that of the abrasion on her lip and a photograph of the scar resulting from that abrasion that was there at least 6 days afterwards in the photographs that the district attorney's office took. And then finally, the Court of Appeals has reminded us that we have to look at the viciousness of an attack when we take all of this into account. And of course, this is the type of attack that would be normally expected to bring more than a little pain, and that's how the Court of Appeals has phrased it. In Chittick, the seminal case on this, it was a bite to a fingernail and some bleeding. Here, of course, was a vicious attack, as I've already gone through. If there are no questions, Your Honors, we ask that you affirm.
Thank you. Rebuttal?
First, I want to read from the People's Brief at page 49, where it talks about the pain location. The brief reads, the pain severity score was a 6 out of 10. The report noted that the pain location was in her throat, as well as her leg and buttocks. So it's unfair to say that we're mischaracterizing the record. That's from the People's Brief. Second, even assuming there was physical injury here, it was entry-level physical injury. The dangerous instrument was an entry-level dangerous instrument, and my client has nothing in his record that warranted the maximum sentence. Dangerous instruments can be knives, they can be guns, and they can also be rolled-up newspapers. This is not the type of weapon, dangerous instrument, that warrants the maximum sentence, nor are these the type of injuries that warrant the maximum sentence. As you know, physical injury covers a lot of ground, everything up to injuries that are serious physical injuries, which are injuries that are serious disfigurements, protracted disfigurements, and life-threatening injuries. These injuries, if they're physical injury, a cut lip, a gag reflex throwing up, a pain level of 6 that 3 hours later was 0, are not injuries that warrant the most serious punishment. Nor is there anything in my client's record that warrants the most serious punishment, 7 years. If this were a misdemeanor assault, which this was elevated only because of the use of the newspaper from a misdemeanor assault to a deviolent felony. If it were a misdemeanor, the maximum would have been a year. The fact that he used a newspaper meant that he got 7 years here. That's just unwarranted under the circumstances. He had a single prior conviction in an otherwise law-abiding life, and the maximum sentence was not warranted. Thank you.
The next case is Verghese versus Concourse Residential.
May it please the court, my name is Marcy Sonneborn on behalf of the Concourse Hotel. In this case, the plaintiff testified that he slipped and fell on a milky substance on the stairs of the Concourse Hotel at approximately 8 p.m. He said the milky substance fell out of a garbage bag that one of the porters had hauled down the stairs. The hotel moved for summary judgment based on the law and the facts. The first point that we made is that the hotel proved that it cleaned and mopped the stairs twice a day at 7:30 a.m. and again at 3 p.m.
How did the hotel prove that, Councilman?
Excuse me?
How was that proved?
Several ways. We proved that with the affidavit of the general manager, with the porter who did the cleaning, and those were two affidavits we submitted. And
Were those witnesses disclosed for the first time at the summary judgment motion?
The plaintiff claims that they made a discovery demand for the names of witnesses. Neither the manager nor the porter were witnesses to the accident, but be that as it may, we have several points. Number one, there's absolutely no prejudice. The plaintiff lived in the building. The general manager had an office on the first floor. He didn't need the defendant's attorneys to tell him who the general manager was. We produced his case manager for deposition, and that was, I think, in 2015. 3 times she was asked about the cleaning schedule, and 3 times she said, I'm the social worker. I don't know about the cleaning schedule. You have to ask Mr. Maurice, the general manager. But the plaintiff did not ask for a deposition of Mr. Maurice after being given that information. We submitted, as I said, the affidavit of Mr. Maurice. There was no motion to preclude. The trial court accepted these affidavits.
Wasn't there a number of requests for information on the person that cleaned and for any reports of the cleaning routine at the building? And this was made on a number of occasions, and actually there were 4 orders issued by the court, and none were complied with.
Your Honor, I agree. However, as I said, the manager was on site every day. He worked for the hotel for over 10 years. The porter was on site every day. There was no motion to preclude. The trial court has great discretion when it comes to discovery matters, and these 2 affidavits were before the trial court. The transcript of the hearing on summary judgment is in the record, and the trial court never said, I am not accepting these affidavits because you didn't provide these names. There's absolutely no prejudice to the plaintiff. Had the name been provided...
Let's assume you made out a prima facie with these witnesses. Why isn't there an issue of fact based on the wife Maria's observation in the staircase, I think 3 hours earlier of Angel's Fall, that the stairs were littered with garbage?
I'm so sorry, Your Honor.
I'm sorry.
I'm so sorry. I did not hear your question.
My question is why doesn't Maria, the wife's testimony, raise
Correct.
an issue of fact based on her observations of the staircase 3 hours prior to her husband's fall?
Correct. There is no evidence in the record of notice to the hotel of a condition on the day of the accident. Maria said that she complained a week and a half after she moved in, that's 7 months before the accident. The plaintiff, her husband, was asked numerous times, when did you complain? Did you complain about the condition of the staircase? No, I did not specifically complain about the condition of the staircase. He did not remember who he complained to. Now, the cleaning staff and the managerial staff is there from 8 a.m. to 4 p.m.
Wasn't there a neighbor who also complained about the condition on the staircase?
Never on the accident date. In fact, the neighbor really confirms that there was cleaning twice a day. Mr. Crute, Kevin Crute, says I saw them clean in the morning. I saw them clean in the afternoon. I would like to get his quote for you. So when he's asked about cleaning, so I mean, they cleaned it and it looked good. This is on page 605. And then when they are gone, the place is back again, a junkyard again. So this is what we have. We have a situation where there is cleaning, mopping, inspection every morning, every afternoon. The accident occurs at 8 p.m. The cleaning staff is not there. The managerial staff is not there. The security staff is there. And the affidavit says that the steps were inspected after the accident and that they were clean. The case manager says, because the building didn't have an elevator, I walked those steps every day to see my clients, and I never saw debris on the steps. So there's absolutely no evidence to suggest that whatever debris the plaintiff claims he fell on hadn't just been deposited there minutes before. I mean, he never said that he saw it at 5 p.m. And by the way, the defendant's narrative is completely consistent, whereas the plaintiff's narrative is completely speculative.
Counsel, I have a question because there's also testimony that Mr. Verges allegedly said that he fell on a candy wrapper. And
Correct.
So doesn't that raise issues of credibility which cannot be decided on a motion for summary judgment? So the denial was appropriate. You have two versions. You have conflicting stories. That raises credibility, correct?
Respectfully, no. There are three versions. The wife says, my husband said I fell on a candy wrapper, and that's what's in the accident report. The plaintiff testified, I fell on a milky substance, and his friend testified he fell on 30 pieces of garbage. So it would be complete speculation for a jury to credit any one of these three versions, but the jury doesn't have to get there because the law of this state, of this department and of the Court of Appeals in the De Jesus case says if you prove that you cleaned in the morning and you prove that you cleaned in the afternoon, you are not required to clean 24/7. That is not the law of this state. There is no notice on the day of the accident. The notice that is given is vague in general, and there's never a timeline for it. And we proved that we cleaned morning and afternoon the day of the accident. There's inspection after he fell. The steps are fine. So you don't have to get to the credibility of which of the three accounts that the plaintiff has given is the account to credit. You don't have to get there. There's no liability when you prove the cleaning schedule.
Right, but counsel, will you agree with me? Will you agree with me that the law is clear that when we have issues of credibility, that's not to be decided on a motion for summary judgment? Will you agree with that?
No, Your Honor, respectfully not, because you never have to get to that. We've proved cleaning. We've proved
Well, if we did have to
our
get to
duty.
that, so if we did have to get to that, that's my question.
Well, if you have notice, which you don't have, let's say you have notice at 5 p.m. The wife says, the husband doesn't say that, and he testifies for a great deal of time, but the wife says at 5 p.m. there's debris on the steps, okay? The husband never says that. If she then said, I went and I told the security desk, because at that point the manager and the cleaning staff are gone, I went and I told the security guard, please clean that up. And then at 8 o'clock her husband falls, you have a completely different situation than what you have now. What you have now is twofold. We proved cleaning and inspection under the law, and we proved there's no notice on the day of the accident.
I'm going to just push you into a different issue, and I know we're long past your time, but I just, accepting that on the issue of notice, that the showing of a reasonable cleaning schedule and that it was followed in the law of this department proves that you didn't have notice. If, in fact, the plaintiff who testified that the condition was the result of liquids dripping out of the garbage bags that are carried by the super, is that a cause and create case that it would at least And that doesn't require notice. That would at least require that there be no summary judgment.
Respectfully, no, for two reasons. We have evidence in the record that the porters took the garbage down the steps as required before 9 a.m. So you have the afternoon cleaning after the porters take the garbage down the steps. The plaintiff himself said, I take my own garbage down the steps. I don't wait for the porters at 9 a.m. His friend who testified, Mr. Crute, said, that liquid I saw on the steps could have been liquor from one of the tenants. It's complete speculation for a jury to conclude that the milky substance that the plaintiff fell on at 8:15 at night could possibly have been from a porter who took garbage down the steps before 9 a.m. There is absolutely no evidence as to how, whether it be a candy wrapper, a milky substance, or 30 pieces of debris, there is absolutely no evidence as to how it got there, who put it there, and there is no notice to the hotel of that condition.
Okay, thank you.
Thank you.
The next case is People versus Anonymous. You can proceed, Counselor.
May it please the court, my name is Anjali Pathmanathan and I represent the appellant in this case. Beginning with the Miranda violation here, we have a situation where approximately 18 officers rammed into my client's mother's apartment at 6:40 in the morning with their guns drawn and pursuant to a search warrant. They arrested my client immediately upon entry, handcuffed him, and placed him in the living room with his mother.
Yeah, let's assume for a minute that he was in custody, and they certainly didn't give him any Miranda warnings. To me, this issue turns on whether you believe one of the officers who testified, I told everybody what I was doing there, that I was executing a search warrant for a gun. Or there was other testimony, conflicting testimony, that he posed a question, where is the gun? Was there sufficient evidence for the court to believe the officer rendition that there was no inquiry, just a statement of what the police were doing there? And does that change the disposition?
Your Honor, the decision is erroneous either way, but I'll start with saying that first, the officer testified that they had informed, Detective Dye had informed my client that they were there to execute a search warrant pursuant to a firearm, and then said that my client answered with the statement, there's a firearm in my bedroom. On cross-examination, it was confirmed that the detective actually asked my client, is there a firearm? Now, when you look at the testimony as a whole, that's the final statement, that's the final testimony that comes out. When it's a question, we're in the situation of People versus Perry, which is this court's case from 2012, where a question was asked of the client in custody that was certainly designed and reasonably likely to elicit an incriminating response. Even if, I dispute that this is the final testimony, but even if Detective Dye just told my client while he was handcuffed, while there were 18 officers with their guns drawn in his mother's apartment, if he just told him that they are there for a firearm, we're still within the realm of the functional equivalent of interrogation. We're still within the realm.
Why is that? Doesn't an officer who comes in who's executing a search warrant have to tell the people who are in the premises of the search warrant what that officer is doing there?
That's not the order in which the events happened, Your Honor, right? We have the police ramming in a no-knock warrant into the apartment, arresting my client, putting him in handcuffs, placing him in the living room with his mother also in handcuffs, and then telling him, we're here for a search warrant. So whether the officer then uses the specific vocabulary, is there a firearm in the apartment, or whether he says, we're here for a search warrant of a firearm, where there's a firearm in the apartment, whether there's a firearm in the apartment, it's still vocabulary that's deliberately eliciting an incriminating response from my client.
Counselor, let's assume you're correct. Let's assume that, in fact, that there was a custodial interrogation. Wasn't this harmless error?
Certainly not, Your Honor. This statement
Well,
was...
where was the gun found?
The gun was found in a closed drawer in a bedroom.
In the bedroom, right.
In his mother's apartment.
In his, but whose possessions were in the bedroom where the gun was found?
There's no testimony of that. I submit that the prosecution
There
never
was
submitted any
nothing-
evidence.
There was no evidence that defendant had other possessions in that room?
The only testimony that came out of anything that belonged to my client in that room was a wallet that included identification.
Well, generally speaking, you said 6:30 in the morning, right?
6:40 in the morning, yes.
6:40 in the morning, wouldn't it be reasonable to assume that a wallet would be in a bedroom where you're sleeping?
At most, Your Honor, it's reasonable to assume that he was an overnight guest, where in that wallet there were 4 identifications, and all of the valid current ones were from out of state. They registered my client's address, not in New York, where he's in his mother's apartment. There's no dispute that my client was in the apartment with his son.
There was a warrant for the apartment. I mean, there's no dispute that the warrant was validly issued. Your issue is something different.
Your Honor, with regards to the question of harmless error, there's no evidence other than my client's physical presence in the apartment
And
this
his wallet in the bedroom where the gun was found.
that he's not just an overnight guest in that apartment. There's no DNA on the gun. There's no fingerprints on the gun. There's no eyewitnesses.
That's a different issue. There was a search warrant issued for this particular premises, right?
Well, Your Honor, the question is whether it's harmless error. The search warrant is irrelevant to the question of harmless error at trial. At trial, the only evidence besides my client's physical presence and these identifications would show that his permanent address is not here in New York, not in the apartment in which he was arrested. There's nothing else connecting him to this weapon, which is what makes this statement not harmless, because there can be no reasonable possibility that it did not contribute to the verdict when it is the only statement that affirmatively has my client admitting there's a firearm in my bedroom. Now, there's 2 bedrooms in this apartment. There's no testimony of what was in the other bedroom, of whether my client's belongings, other than these IDs, define the bedroom where the gun was
More
found.
than his ID, it was his wallet. His wallet.
Certainly, Your Honor, his wallet. But there's an entire room of other belongings. I've submitted to this court the image of that room. It does not dictate that this is the room of a gentleman who has his child there. It dictates the room of a woman. And while the officer had a very difficult time providing that testimony, answering those questions to defense counsel, when you look at the actual image of this room, it doesn't definitively suggest that that was my client's permanent bedroom. And most what we have is an overnight guest. And where it's an issue of constructive possession, his mere presence in the apartment is not enough to prove that he constructively possessed that firearm. And that's why, beyond the fact that his Miranda rights were violated in this case, because this was a custodial interrogation and because the testimony shows that the officer asked, is there a firearm? If there was a firearm, in the apartment, this statement should have been suppressed, and it was not harmless error that it was not. Now, if I may, Your Honors, I would like to also turn to the count 3 in this indictment that my client was convicted of. This is the unlawfully dealing with a child conviction under Penal Law 260.20, subsection 1. The evidence was legally insufficient to prove that this small quantity of marijuana found in my client's mother's apartment constituted unlawfully dealing with a child. This statute requires that someone knowingly permits a child to be in a place where, quote, activity involving marijuana is maintained or conducted. And where the statute does not define activity, its predecessor statute under Penal Law 484 says that it was designed to protect children against things like prostitution houses, opium dens, and prohibited conduct that endangers...
Exploitation. Essentially, you're arguing there's no exploitation of the child. Was this argument made below?
Yes, Your Honor. This is point 3 in my briefing, and it's count 3 of the conviction against my client. It's the unlawfully dealing with the child statute.
But the argument you're making now was made below?
Was it made below? Excuse me?
Yes.
Yes, Your Honor. So specifically, trial counsel preserved this issue in his trial order dismissal when he argued that the Penal Law 260.20 statute, quote, was not designed and is not created for cases such as this. It wasn't designed for someone's child where someone smokes in the home. And then, quote, facts that came out during the people's case do not support this count. That's on the trial record 311.
What impact, if any, does it have that the marijuana count is to be dismissed as a matter of law?
Your Honor, I've submitted that. Of course, the marijuana count has to be dismissed as a matter of law. I'd also like to just point out the fact that it still has not been expunged from his record, and
No, I'm talking about leaving that aside. That's a different issue, which I understand. But that this appears, and I could be wrong, that this is just a personal use marijuana, and that's why it's getting dismissed under the new statute. Does that have any impact on the unlawful dealing with the child being around marijuana?
Yeah, so in terms of the fact that now that the mere possession of small quantity of marijuana is decriminalized in New York, I think has an import in what is the meaning of this statute. Ultimately, if the statute is designed to protect children against those who are exploiting them for illicit purposes, mere possession of marijuana, non-criminal quantities of marijuana now, should not fall into the statute of a misdemeanor crime against a child. I have argued to this court that this particular statute becomes unconstitutionally vague as applied to my client, specifically for this reason, Your Honor. However, that is not preserved, and so I'm asking Your Honors to look at that in the interest of justice. And I'll reserve on rebuttal. Thank you.
Thank you.
May it please the court, Valerie Figueredo for the people. Turning first to the unlawfully dealing with a child charge. First, that argument was never preserved. Never did defense counsel below specifically state that the charge required the child to be exploited. And of course, he didn't make that argument because nothing in the plain text of the statute requires exploitation. To the extent the defendant relies on the legislative history to attempt to argue that the statute tried to cover different conduct than what was charged here, you can't rely on legislative history to add an element to the statutory text that just does not exist. Second, to the extent that the defendant argues that the activity involving marijuana component of the statute is vague, that the statute explicitly defines what activity involving marijuana is by reference to the exact penal law provision that has to be violated, Penal Law 221.05. The fact that the fact that marijuana possession is now decriminalized doesn't mean that at the time when it was unlawful that the legislature couldn't impose an additional punishment when you now have a child's presence in a place where there was also marijuana. And I think at one
dispute that under the law of decriminalization, that conviction on the marijuana possession has to be vacated.
As a matter of law, the marijuana conviction is vacated. It's a nullity. But this is a different charge. This, of course, involves the unlawfully dealing with a child. And we're not just talking, there was evidence from which one could conclude that it wasn't just the mere possession of marijuana. There was also a scale and there was a lot of glassines involved, so one could infer that he wasn't just possessing it, but he was also packaging it for sale. Going to the Miranda argument that defendant raises, the evidence showed that this was a bedroom defendant occupied, thereby establishing his constructive possession of the gun.
But your adversary says it doesn't do that. He had his wallet there. It's his mother's place. He could be an overnight guest.
We don't have to prove that he owned the apartment. We just have to prove that he spent time there. And we did that because the evidence wasn't just that it was his wallet. He also had identification cards that actually listed that address as his address. He had mail addressed to him at that address.
And mail that came into evidence?
Right. And in addition at trial, it also came out, it was the time of day and the appearance, which indicated that he had slept there. And of course, there were all the possessions belonging to a child. And if one could infer from the fact that his child was present and living in the apartment, that the father was also living there.
But did you have any clothing in there to show that the defendant was also residing in that bedroom?
I'm sorry, can you?
Aside from child clothing or toys, did you have anything to show, aside from the wallet, that the defendant was also staying in that bedroom? Any clothing of the defendant?
We didn't put forward clothing of the defendant, but we didn't have to because again we had his wallet, his 5 different driver's license, one of which identified that address as his, and mail addressed to him. That would have been sufficient to show that he spent time or maybe partially lived in the apartment. We didn't have to prove that he owned it or lived there full time. He could have split time between multiple residences. But the evidence we did put forward showed that that bedroom belonged to him, thereby establishing his constructive possession of the gun.
And what made his statement during the execution of the search warrant voluntary?
The testimony that came in at the suppression hearing on direct examination, Detective Cerny testified that he had informed defendant that the officers had a search warrant and were looking for a firearm. On cross-examination, Detective Cerny said that the other detective had informed the defendant that we were there for a search warrant. The search warrant was for a firearm, and he asked the defendant if there was a firearm in his house. There was a factual dispute as to whether a question was asked. The lower court credited Detective Cerny's testimony on direct examination, and we argue that that factual finding is entitled to deference. And it's supported by the record because during the videotape statement that the defendant gave after the arrest, he was forthcoming and he explained that he provided the information as to where the gun was because he didn't want the officers to go ripping up the house. He never indicated that a question was asked, but the fact that he was forthcoming and providing that information would support a finding that it was a declarative statement merely informing him that what the officers were doing in the apartment. If there are no further questions, we ask that you affirm for the reasons stated in our brief.
Any questions, colleagues? Okay, thank you. All right, rebuttal. Go ahead.
Your Honor, so first, if I can just speak to the factual dispute of the Miranda violation here. The fact that we're even disputing this shows that this was the functional equivalent of interrogation. It shows that the other officer who testified, Officer Kearney, hearing Detective Dye, believes that what Detective Dye asked my client is, is there a firearm in the apartment? So even from another officer's perspective, this was the functional equivalent of a question, which is interrogation. More importantly, when I talk about the harmless error of these identifications of my client's presence in the apartment, the two pieces of information that connected him to that apartment, to that address, were both from 2010. One was an underage license from New York, which wasn't relevant to my client's life in 2014 when he was arrested. The other was also a piece of mail from 2010. So it was not as if my client was receiving mail in all those years leading to this arrest at this apartment. Those are the two pieces of evidence that connect him as a resident to this apartment, and it's admitted that this is his mother's home. At some point, he lived in this home, presumably by these two pieces of old information. More importantly, with constructive possession, when someone is merely in a place that has contraband, the prosecution is obligated to prove dominion and control. This alone, these wallets and identification, is not dominion and control. And that is why the statement is so harmful, because it is the only evidence that suggests that my client has a bedroom that he considers his own bedroom in the apartment. And that's why it needed to have been suppressed.
He didn't say that. All he did was say, there's a gun in that room, in the dresser.
No, Your Honor, he said, there's a firearm in my bedroom.
In my bedroom.
And that is the only thing that makes that his bedroom. There's no other testimony that makes that his bedroom, beyond just being an overnight guest. Now, with regards to the unlawful dealing of a child statute, contrary to my adversary's position, I have not invented this element of exploitation. The Court of Appeals held in People v. Berry this very underlying definition of what activity involving a child requires. Involving marijuana requires. They addressed the legislative history. The Court of Appeals has already addressed the legislative history to show why it's important to understand what activity means. Activity is not defined by the statute on its face, and that's why Your Honors have to look beyond. And that's why I point this court to People v. Berry. And finally, if I can just address very quickly the marijuana violation here. Yes, of course, in 2019, this was decriminalized. But unfortunately, for whatever reason, these violations are still not being expunged from our client's record. So as of Monday, this violation, this conviction is still on my client's record. So I ask your court to affirmatively issue an order ordering it expunged from the record.
Okay.
Thank you very much.
Thank you. Thank you very much, counselors.